Good afternoon, everyone. We didn't have a lot of time. It's nice to see you all here. Thank you, Karen. BJM is talking about interviews with George's family this morning. Yeah, I haven't had a chance to look. At some point, I certainly will. Hello, Aaron from Virginia. Hi, Addie. Nice to see you here. Goldilocks is saying, fancy meeting you all here. Carrie B is asking, are you asking me if I ate something? Yeah, I had a piece of bread. I scarfed down a piece of bread with some peanut butter on it, played a training game with Watson, and I'm back. So during the time when we're waiting for the jury to come back with a verdict, I'm probably going to disappear for a while and have something to eat and get some dishes washed. CB, I feel like that was a short break, yeah. But you know what? Oh, hey, I see somebody from Buffalo, New York. I used to go over there. I used to go to Buffalo for wings. Oh, in Niagara Falls, New York, there was a good wing place there. So I'm glad that this didn't drag on for weeks and weeks. Gina says, "Yeah, can I email you?" Yes. I think the email it is on my YouTube channel under about. You have to click and say you're not a robot, but I think it's Lori and Watson at gmail.com. Hi, Michelle. We have Santa Cruz, California here. Holly says, hello, Watson. Watson says hello back. Goldilocks, will they keep Sarah at the courthouse in anticipation of a verdict? Yeah. Yeah, they won't be taking her to jail and back. They'll have her in holding there. Thank you, Rons from Scotland, for your comment. 60 degrees and sunny in Chicago. Nice, Dave. And Addie, I know you're from New York, New York. I remember that because I remember laughing because you thought I talked funny and you had to get used to it. Good morning, San Antonio. Can we have a Watson reveal? Well, I am planning a video, but why don't I do this right now? Hang on. Hey, Watson, do you want a stick? Come here. Come on up. Come up. Up. She's not usually allowed up. Come on up. Yeah. Whoop. Come on. Come on up. Yeah. I don't know if you can see her. Come on. Yeah. Hi. Say hi to the people. Yeah. You want the stick? Okay. Good girl. Okay. All done. Oh, someone's saying that another YouTuber said that, who's in the courtroom, said the jury wouldn't look at Sarah at all today. Wow. Oh, Sharabella says, I hear no accident, but then I'm also Canadian. I went and did training in California, and I was on Venice Beach, kind of wandering around there, checking the place out, right? And it was, I think, November, and I'm wearing shorts because to me, I think it's warm, and everybody's wearing their jackets and they're cold. And people came right up to me and said, Are you Canadian? I think because of the shorts. You're not late, Criminal Minds. Holly's mom is saying her dog is 10 months old and 44 pounds. Wow. William Carl says it, referring to Watson, there's the real star of the show. And then William says, just kidding. No, it's okay. It's okay. Watson is awesome, and we're a package deal. I'm just going to check the stream. Looks like people are just starting to come in. Addie says we wear shorts in November in New York also. Yeah, you're north, right? So I could see that. And people in Buffalo too. They get snow, man. Like a lot. Hi Martha from Alberta. Yeah, Martha in Alberta is saying if it's at least plus 5 Celsius, we have our shorts and tees on. Yeah. Criminals asking me if I could consider following the Courtney Clenny case. Oh, really? I thought that was done. Is that the only fans thing? J Mac is painting and saying, normally they paint with bright, vivid colors, but it keeps turning out dark. Very interesting. Oh, why did I pick Watson? Hang on, I'll tell you. Okay, I just want to check the stream. Okay. When I was getting a dog, I got her from a reputable breeder, and we hadn't decided on the dog yet. And the purpose of getting the dog was to train for search and rescue. So we were coming up, my family and I were coming up with names, and one of the names was going to be Radar, which ended up being the name of the dog in the book that I wrote. Anyway, based on Watson. And everybody liked the name Watson because at work, my nickname was Holmes. So everybody thought it would be cute that I named the dog Watson. So the name was kind of pre-picked. It was a choice between those two. And so when I got her, just her behavior and how smart she was and everything, the whole family said, yeah, it's got to be Watson. We like that. So that's what we did. Katina says, I missed the last hour before lunch. Anything huge happen with the jury instructions? I wouldn't say so, no. Somebody else might have a different opinion in the chat. J Mac, SAR is such a commendable job. Yeah, but my problem is that Watson scares the crap out of everybody. Addie, my nickname was at work was Holmes, like Sherlock Holmes. So Holmes and Watson, right? We're a team. So Al's asking me, why did they call me Holmes? Because I was always the one that asked the question that no one thought to ask. I was the one who said, but what's missing? What fact is missing? And sometimes it was really irritating, actually. So, and then I would notice details. I get really focused in on details. And I'm curious, like, why is this way and not this way? So they just started calling me Holmes. Oh, Scully, you're in Tennessee? Thank you, Giovanna, saying Watson is beautiful. I think so. Mad Mystic. Lori, I think you would have been fun to hang out with in the break room. Yeah. Yeah, we had fun. Oh, Denise said, I thought it was like in House MD, Holmes and Wilson. I see. I could spend hours chatting about true crime too. It's bad because not everybody wants to talk about that stuff, right? But something, I don't know, something in my brain lights up when it comes to noticing things that are out of place. I like analyzing things. It's very non glamorous because a lot of my job was sitting at a desk, going through reams of paper, looking for those details and asking questions and picking things apart. Oh, Martha's talking about her recon cat. That's funny. The Heart Machine says I try to watch the less gruesome ones. Yeah. Oh, Criminal Minds, what is your job? You like analyzing language. That's interesting to me too. What is your job? And you don't have to say if you don't want. Hi, Stell. Say hi to your two German shepherds from us. Leslie, you watched true crime, debates, and Buffy reactions. That is an interesting combination. Oh, criminal, you teach English and literature. See, that's very interesting to me. Only because I write and I think I'm not very good at it. So, I mean, I got published, but still. J Mac is asking if I'm retired. For technically I am. I sometimes I still consult, but yeah, technically yeah, but I can't do nothing. So so I ended up writing a book and I still end up doing research and I still get all my professional journals because I don't know. I don't know. I think I just have to do it. Leslie is also a writer. English history. Oh, that's interesting too. You guys are an interesting bunch. Denise is saying, I wish the Crown Courts had more transparency here in England. We still have court sketch artists. Yes, it's the same in Canada. And I mean, I understand publication bans to protect victims and all that, but I think that people would sometimes be less outraged if they understood all of the law and all of the facts. And so they just have to rely on a reporter's understanding of it. And I can tell you from experience that, I'll work on a case and then I'll see it reported in the paper and think, what? Is that even the same case? So, oh, Super Kelly is a dog trainer. Maybe you can help me stop Watson from scaring the crap out of people. William Carl is asking about my book, Fire. It is fiction, it's an easy read. So many books and movies are about the American justice system. So I wanted to write about Canadian detectives. So it's about two Canadian detectives, and the one detective has a dog, and that dog is actually based on Watson, and they solve crimes, and it talks about sort of the relationships between people within the criminal justice systems and how things go down like that. So, am I Virgo? I don't think so. Yes, Rel, there are a lot of interesting people in the chat. I really like hearing what people do and where you come from. It does affect the way you think, right? Shmita, my background is in broadcasting. Really? Interesting. Carrie, doing your master's in astrophysics. Oh, my word. Thank you, Rita. If you request that your library gets my book, that helps me a lot, actually. Scully Officer says, I only recently realized Watson is female. Cool girl dog power. Yeah, and people say to me, "Oh, why'd you give her a boy's name?" She doesn't care. I'm seeing somebody in the chat is a chemist. Very interesting. Oh, Criminal Minds, if you review my book on Goodreads, please be kind. Yeah, there are a lot of creative people in here, a lot of artists. Aaron's in medical billing, computer sciences. Very interesting people. Amp Tech Ron says Owens is helping put Sarah in prison by his effective counsel. No appeal. Yeah, they'll try and file one. They'll try and file one anyway. Hi, Romeo Saints. Oh, Romeo Saints, you're a musician. I used to play piano. Only got to grade 9, though. Scully, retired radio broadcaster. Interesting. My stepfather was a radio broadcaster. Tevi, your daughter has a female cat named Henry. I like it. A hydrologist. What is a hydrologist? I don't even know what that is. Very interesting people. Oil Guy Gamer, an oil rig accident investigator. No amount of investigating can help me find your book in EPUB format. I think it's only in soft cover. We're just gabbing. Somebody asked what we're talking about. We're just gabbing, waiting for court to start. They did say 120. Oh, surface water scientist. Interesting. Watson's chomping on something behind me, so if you're hearing that, that's what it is. Oh, Scully named your German Shepherd after Attila the Hun, and I'm sorry for your loss. Dog owners know. Well, you know what? I'm not going to say dog owners, pet owners know. Princess Peach, I have 700 toads. Literally? I love frogs and toads. If you mean that literally, then that's really cool. Rel says they must be waiting for Owens. The Owens jokes in the chat. You guys are you kill me. Somebody said, I think it was in the comments. Somebody get a oh maybe it was in the chat. Owens needs because I was saying, oh, they need binkies at council table and Pop Tarts. And someone said, and a white flag for Owens. He can wave it from under the table. Princess Peach says, like in the Mushroom Kingdom. Oh, the toads. Very interesting. Okay, Martha, I see your comment and I'm laughing. I don't know if I'm going to read it out loud. KPM Interior Designer. Paige, operating room nurse here. Ooh. And your dog is a most perfect boy named Fenton. Cat, you have an owl called Haggis? That's great. Jane, I asked my publisher if I could do my own audiobook, and they said no. So I have a contract, so when their rights expire and I can get my rights back, then maybe I will do it myself anyway. William Carl is saying about the all of you here. Wonderful slice of society here. Yeah. Yeah, Romeo, but you know what? The publisher, it costs them money to do all this stuff, and they have, I don't know, their contracts and, right? I can't argue too hard. It's not like I'm Neil Gaiman or Stephen King or something. So someone's asking if we can watch the new family video together from Court TV. I cannot do that. I would be breaching copyright law, and I try very hard not to break any laws at all. My cat likes true crime, says George's cried in the police body cam still hurts me. Yeah. Rel, yes, I can still do my book when I get the rights back, but I have to wait. Criminal says Stephen King is my favorite author. I don't think I have a favorite author. I like the Russian authors. What the heck, man? So they were supposed to be back. Whoops. Even the jury was supposed to be back at 1:30. Oh, thank you, Tina, for asking your library to get fire. Oh, so you ended up not being able to do it, but thank you for the thought anyway. So you guys are naming authors like Clive Cussler, Dean Koontz. Cat Lady likes American Gods by Neil Gaiman. His I like his books. I like his imagination. Tiffany's asking if she can still take the plea. I mean, I okay, let me answer this correctly. The fact is I don't actually know the answer for sure. I would think not, but I don't actually know. Lionel says Sarah's in hair and makeup. I J Mac is asking about covering Corey Richens. I have covered her. I have some videos. I don't have any lives. I wasn't doing lives yet, but I have a Corey Richens playlist. So yeah, I'll follow up with that. Chris, if she's guilty, does she go straight to prison? No. So she has to be sentenced first, and so they're going to have to set another date for sentencing. The Heart Machine is saying 15 years is not enough to teach Sarah a lesson. Honestly, I don't think there is an amount of time. I don't think she's going to be turning around. That's just my opinion. Holly's mom is saying, "Can you imagine how many letters will come from Sarah Boone after sentencing?" Meh. She can whine. She can whine. And where is she sending them to? What, the clerk of courts? No, not sending them there. Where is she sending them? Somebody says it's talking about Sarah's hair and makeup. It's hair and makeup, not a magic wand. That's funny. Gina saying some judges sentenced the same day of verdict. Yeah, I would expect that Owens and Henderson would want a pre sentence report. Marco is saying Sarah has Owens cornered in the break room yelling, "It was a good day." Yeah. You know, if she's found guilty, we should all say it was a good day. It was a good day. Unhyphenated is making a very good point. Some crimes are about mistakes and bad choices. Yeah. Sarah's is about who she is. Yes. And that's why I say that she would be a risk if she was just out in the community, because it isn't about somebody finding themselves in a terrible situation and under resourced and not being able to figure out the right thing and all the tumblers fall into place. It is who she is. That's right. The minimum sentence, if she's found guilty of second, the minimum is 22 and a half years. But there are aggravating factors here. Oh, Nikki's saying there needs to be an assessment to take into account her behavior in the jail this this last 4.5 years. We'll see. We'll see. The judge, I have no doubt that the judge is going to follow the law. And when there's a question, as we saw today, there was that issue between the essence of the law and the letter of the law. He went with the letter of the law, and you could see him. It was a tough decision for him on that particular issue, because I think he could see Mr. J's logic, but the law said what it said. MH is asking, do I think Sarah will be a target by others? I don't know. I don't think that anybody in custody, whether you're in custody or out of custody, I don't think you should be a target. Lizzie M says, I imagine her parole hearings will be more of the same. I did nothing. What is going on here? I'm going to check and make sure that the stream I'm looking at is not having an issue. Nope. Nope, we're good. Giovanna says, I think Sarah can hold her own. Yeah, she said, I made friends. I have friends in jail, so. Supercalifragilistic says the depravity may add much to the sentence if convicted. Well, the depravity is part of the charge, right? So the fact that it's part of the charge is factored into what the sentences are, the law on the sentences. Someone's saying Sarah can teach arts and crafts in prison. I hope she's not put in a position to teach anybody anything. She should never be in a position of power at all. Scully officer says, I keep thinking of George addressing the judge in that video. Hope that hit the judge's heart. Yeah. Especially when he says God will prevail. Oh, yeah. And that in itself, by the way, is a crime. You can't. What she was doing in that video in itself is also a crime. Yeah. The range is 22 and a half years to life for second degree. You're correct, Karimina Wines. She has shown no remorse. Diana's saying, I'm glad that the child and Brian escaped her psychological, yeah, what she was doing. And I think that things would have got worse for Lucas. Oops, I said his name. For the son, I'll put it that way, as he got older. As the child becomes more independent, and a parent like her starts to lose control, things can go really sideways. Holly's mom says she delights in victim blaming George. Yeah, that's common. It's common among offenders. And when we're doing threat assessment, one of the things we look at is, does the person adopt the victim stance? And that is very different from being an actual victim. It's not the same thing. But adopting the victim stance allows for justification for retaliation. So, like she's saying to him, you brushed me off in the car. We talked 90% about your day and only 10% about my day. And she's adopting the victim stance like he's done something to her and it's unjust. And this is just another one of those grievances she's collecting. And she will, and she kept a record of all this stuff. And she's vengeful. So that provides her justification to do evil, right? In her own mind. It isn't justification, but in her mind. So if you see that, if you see someone just adopting the victim stance, especially when it's extreme or unreasonable, just, I'm not saying that that's the end of it. There are a lot of tumblers that have to fall into place, but make note of that when you see that and look for other things, because if that's going on in combination with other variables like vengefulness, like um, not having anything to lose. A lot of people would be dangerous, but they're kept in line because they knew if they acted out, they'd lose their job or their reputation or something. So, when you see those things, go, okay, what combination of things do we have here? Oh, Scully says, I've rewatched the video of her explaining the TV to the cops. She did tell them they dropped it prior to that day. Hmm. I feel bad for her son. Will Sarah have access to YouTube in prison? I don't know. I don't know. Does anyone in the chat know that? Cat Lady, your Beware the Fantasist video was so eye opening. Thanks. Thanks. It does apply to other things, right? Like you could see how other people could display a trait or behavior like that and how you need to watch out for that. Criminal Minds, this Sarah Boone case is really teaching me about how to spot people like her and avoid them like the plague. Yeah. Nala stole his spoon. You are not behind. Court is behind. We're still waiting. They were supposed to be back half an hour ago. So I don't know what's going on. Jenny, did you catch on the video of George that she was accusing George of drinking all the vodka, and she said two people could have had a good time on what was left? Yeah. Yeah. So her issue isn't really that he had something, it's that she believed that it somehow deprived her and that he didn't do that with her. It's all about her. It always is. Iran saying, notice when Sarah brought up the bat in a few vids, she always tied Lucas' name to it. Well, it was Lucas's bat, but she did at one point say, sort of imply it was there for self defense. The other thing I noticed is how she used Lucas on the 911 call when she wanted the police to come get her at Brian's and take her, and drive her back to her house. She's saying, I have an 8-year-old here I have to take care of. No, she didn't. No, she didn't. He was with Brian. And by the way, that was after 1 o'clock in the morning and they didn't show it in court. But what she did was she dragged the child outside to greet the police. Why are you doing that? He should be asleep. Scully's saying it's interesting going back and looking at my old interrogation videos of Sarah saying I nailed her. I think I would have lots to add now. But I got in a lot of crap back then because I was being so mean to her. Zombie Blend. Wanted to say thank you, Lori, for what you said at the end of yesterday's stream. Thank you. Thank you. And thank everybody in chat too. I mean, you're all terrific. I saw a number of damn it Margaret jokes in the in the chat yesterday. It was pretty funny. Supercalifragilistic? Yes. Well, my understanding is it was Lucas's bat. That she said Brian bought it for her. But you know what? If she says something, who knows what the truth is then? KPM, she didn't want to be arrested that night and just wanted the cops to go kick him out so she could bring a friend home. Yeah, because they didn't show that in court either. At the very end of that body cam video, she said, "Well, can I call a friend over now?" And the police officer's like, "I don't care. Do whatever you want. It's your house." Martha, I think the damn it Margaret jokes. I think it's like a meme. Everybody's saying, "Who's Margaret?" I think it's a meme. I don't know what it's from. If it's from a cartoon or an old show or something. Amp Tech Ron says Owens can't wait to block her calls. Yeah. True Crime Boozer says the police were a scheduling tool. Yeah. Holly's mom says your chat is my therapy. Thank you. It's the rest of the group here. It's not me. You guys are terrific. Oh, Margaret is Owen's assistant back in Milton. Oh, I've seen damn it Margaret memes on the internet. And Owens was blaming Margaret for everything. Oh, I didn't get that. I do. Thank you for explaining that. Well, that makes it funnier. It's Owen's secretary. Damn it, that he throws under the bus all the time. Okay, that's funny. Jay-Z, yes, she'll get a new attorney for appeals. That's correct. Why are they taking so long? I don't know. Paige is saying that this chat had her laughing with the Owens one-liners. Yeah. Sometimes you gotta laugh. And you guys are hilarious. I've learned on my YouTube channel, so I grab my coffee in the morning and I just check out the comments because even though I can't always respond, I like to know what you think. And I've learned not to have a sip of coffee in my mouth reading those comments because you guys crack me up. And in the vodka video, when Sarah said there was enough for two, George immediately turned the wall and made himself smaller. Yeah. Yeah. So, I mean, this is a conversation or a type of interaction that had occurred before, and he knew what was coming. He knew what she meant. He suffered BSS. She wouldn't let him go. Frankly, Owens, I don't give a damn. Ollie's mom says. I'm going to check this stream again. What is going on? I'm going to check. Maybe I'll check some messages and see if there's any kind of info from the courthouse. I'm seeing nothing. Yeah, I don't know what's going on. Cray Cray is the nickname here. The handle is Cray Cray for Kranick. I like that. How old was Watson when I first got her? I met her when she was 6 weeks old, but I couldn't bring her home until I want to say 13 weeks. There were a lot of things that needed to be done, and it was unhealthy for her to come to me sooner. So whatever date that was. And it all had to be okayed by a vet and all that stuff. Nope.
We're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. Limited appearances for the state, please.
Dave Ketchcore on behalf of the state. Will J for the state.
Defense.
James Owens for Ms. Boone.
Tony Henderson for Sarah Boone. Kevin Beck on behalf of Sarah Boone.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. I apologize for my lateness. I realized that there were some typos after I'd sent this to print and needed to take them all apart to fix it. So thank you for your patience as we work through that. State.
We noticed that in the non-deadly force,
Page 12.
there was a couple strike-throughs with the use.
I saw.
However, there was also a mistake with leaving a paragraph about reputation in at the very end of 3.6G, and that should have been a mirror of the relative physical capabilities of the parties.
I do see that.
Other than that, I saw the he-she bracketed still.
I fixed that on page 16.
And then it's just that one, I think, that Mr. Henderson and I noticed.
Okay, all right. I can have Madam Clerk start fixing them here.
Yeah, I think we should proceed and get going if we can.
But they will have nothing in their hands.
All right, well,
That's the issue.
all right, let's face that one, dude.
Sorry. All right, thank you. Just give us a minute to fix all this.
So
Yes.
there was a clause left in there that shouldn't have been. So that's going to be important for them to take out.
And just so that I'm clear back on the record, we're referring to the bottom of page 12, 3.6G, paragraph 2, where the use is struck through, correct?
Yes, sir.
And then we're referring to the top of page 13 as to that 2 lines as to reputation. Is that correct?
Yes, sir, that should be physical capability paragraph or sentence.
Let me pull back up to 3.6G instruction.
Yeah, I don't know when this judge has time.
So that
to
reputation paragraph should be removed in its entirety, and it should be the,
In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres.
there it is. Thank you. Take it, 10, 12, and 13. Thank you. 12 and 13. Thank you. Very strange. It is not letting me copy it over, and I don't know why. Correct.
Someone said in the chat, all I can say is I've never seen Sarah and Satan in the same room. I thought that was funny.
Was there anything else other than that? If you find George Torres had a reputation for being a violent and dangerous person, you may consider this fact in determining whether he was the initial aggressor. Anything else that needs to be added to the jury instructions from the state side of the ledger?
Well, the reputation should be deleted.
Correct. I agree with you. Yes.
Just that
I'm
physical-
sorry. What the heck? What's going on here?
No reputation, Judge?
That's correct.
What does that state exactly? Is that down here?
Oh, Owens, sit down. Henderson got this figured out. Just stop it. Go get your binky.
Mr. J, was there another line that we had added to the end of that?
I don't believe so. The physical contact sentence is where it should be.
Okay. Maybe that's what I was making. Maybe that's what I was thinking of. So the sentence should read, in considering the issue of self-defense, you may take into account the relative physical capabilities and capacities of Sarah Boone and George Torres. Is that correct?
Yes, sir.
All right, thank you.
36F.
Correct. It matches 36F now. I apologize. I'm going to have Madam Clerk, I'll email it to her now, have her print out pages 25 copies of 12 and 13, and we'll start taken apart our jury instructions and re-adding them. And I thank you for your patience. 12 and 13, that's it. Mr. J, are you going to be utilizing the verdict form in closing?
I am not.
Mr. Owens, are you going to be utilizing the verdict form in closing?
I may, is it going to be at your bench?
Yeah.
I'll ask you for it if I need it.
Very good, sir. Thank you.
Judge, when you get a chance.
No, go ahead, sir. I can multitask.
I know there's a mic here. I know there's a mic right here.
I will confirm with court admin that microphone is on. I believe it is. They turned it on during openings. I'll confirm now.
And then, Judge, last time I used this fingerprint table as my podium.
That's fine.
I may just slide it back so I'm.
That's fine, sir.
And then, Judge, I've got 2 tripods.
For his
And I've got
placards.
some demonstrative aids. One is this. It was originally a quote by Dr. Michael Brannon.
Objection. Objection.
P.T.
Okay. May
Barnum.
proceed. What are the other enlargements, sir?
It's
No
it's the
objection.
one I tried to get in.
I hear no objection.
An opening, which was the justifiable use
No
of
objection.
non-deadly force.
No objection.
Those 2. And then,
Okay.
you remember my reasonable doubt? I was using it for.
You've seen them?
I
Okay.
had no objection to those 5. I didn't like the 3 charts. The defense agreed that the we found reasonable doubt charts they won't use, so I think we're all good on their charts.
All right. Very good.
And the only other thing I'd want to use.
But we're good with their demonstrative aids during closings that we were used during trial.
Okay. Very good.
I've got 2 videos that I'm going to want to play, and Shelby Andrews is going to walk up.
They're in evidence, right?
They are.
Yep. We're good.
Okay.
One of them's been pared down.
That's fine. As long as it's in evidence, you can present whatever you'd like.
And Judge, do you want to talk about time for closing?
We can. What do you think, State? You advised an hour and a half.
Yeah, I think we both said hour and a half, but as the court knows, you can't really hold us to it until it gets a little ridiculous.
That's true. How much do you anticipate, sir?
Well, Judge, she's charged with murder. We've had a 2-week trial. I've got a lot to say. I've got a lot of notes.
Got a lot to say. Of course you do.
We're good. Let's go.
Say again?
I'm not hearing any,
Okay.
stammering
The
for
only thing I
clamoring
would
from the
ask
state.
is after the state has had their first opening, give them a short
Agreed.
break, and then let me start.
Agreed. We'll take our afternoon break at that point in time, then we can proceed with the defense closing and then rebuttal. I have received approval from the chief to work after 9 o'clock. So we can go till about 10, maybe a little bit thereafter.
And then you're saying with the jury. And
Correct.
then at 10 o'clock, if we hit some number, 10 or 11, then we would come back Monday?
That's correct.
Friend of mine is a pastor, and he has a saying: never pray for patience, because God will give you something that will make you pray for it more. cat lady says she feels like when she listens to Owen speak, she's being covered in oil. I think it's an interesting exercise, even if you don't like him. I mean, don't watch if it really, really bothers you. But I think it's interesting to see different tactics, to
Thank you.
sit back and examine the different ploys. I had a hard time listening to Lally. He drove me crazy. Oh, Secret Squirrel says, also never pray for an exciting life. Yeah, definitely. I think there's an old Chinese curse, like maybe you live in interesting times. That's not a good thing. Nikki, Lally was a form of torture. Really. Just repeating, mixing things up on purpose. Just, it was like it's like having somebody drilling into your head really slowly and painfully. It was awful. Lisa says, the Scrambler, new menu item at Denny's. Just ask for the Owens. You guys are so funny. Linda, yeah, I think Lally was more irritated. Lally just made me want to rip out my hair. That drove me bonkers. So someone's saying, yeah, look at the prosecution table. Well, I don't know that Jay looks cool. I guess so. I think he's under a lot of stress. Cacciatore looks almost bored. Hey, what's going on here? I don't know why my stream does that. Or my feed. Oh, sorry. We're talking about, some people don't know who Lally is. Okay. Sorry. We're talking about this. I should have explained. Lally was the prosecution in the Karen Reed case. And that was that was something else. She's going to be retried, I think, in January, right? Giovanna says Mr. J is prepared for Owen's BS. I think I think these guys, these prosecutors are going to be so happy when this is out of their hair. It's going to just be such a relief because Sarah Boone has just been a thorn in their side for how long? And this, my understanding is this is a pretty small office. This prosecution team are outgunned by the defense. And usually it's the other way around. Usually the state has much more in terms of resources and time and manpower and all that. It's the other way around for Boone. She has received incredible benefits. Most defendants don't get what she got. Some people are really liking Mr. Cacciatore. I think because of my age, I look at him and I think he's like my son's age group. Like, yeah, I can't even see him like that. So someone's asking me, what, if anything, bothered you about it? Oh, I get it. You know what, though? I say what, if anything, all the time because that's what I mean. And that is a phrase that, I mean, I hear all the time up here because it means when you say what was there, well, maybe there wasn't. So you don't, so you want to include the possibility that there wasn't. So you say, if anything. Mind you, Lally used it improperly all the time. So I catch myself saying that and I think, oh man, everybody's going to think Lally. Uh, Someone's asking, a lot of people were upset with protection. I'm not sure what you're referring to. So I'm not sure if you're referring to this case or another case and in what way you mean protection. Sorry, Tracy, I missed the question. So Tracy, I saw you ask, I saw that I missed a question, but I don't know what the question was. Somebody's telling me I can still fangirl. Yeah, I fangirl over different things though. Okay. I'm waiting for this question that I missed to come up again. I'm not seeing it. So I apologize for missing it. Oh, Tracy's asking, what was going on? What are we waiting on? You were late by an hour. Oh, okay. You were late by an hour, which means you didn't miss anything because court was really late. They are ironing out some bugs. There were some errors, basically Scrivener's errors in the charges to the jury. So they had to fix that. And now they have to make 25 copies so that the jurors have them in their hands. So that's what we were waiting for. And then of course Owens got up and started being Owens, basically.
State, are you ready to proceed?
Yes, Your Honor.
Defense, are you ready to proceed?
1 minute, please.
Yes, sir.
We're ready, Judge.
Let's go ahead and bring in our jury. Yeah, that would be fabulous. Just Bruce, come on up. I do not. The instructions. Jury. Thank you.
God, it says Sarah hasn't had to get out of bed and wear shoes for so many days in a row. It's wearing her out. You guys are funny. Anita's saying, are they praying? Yeah, I don't think so, but maybe they oughta.
Jury entering.
She's giving them that sweet smile, the jury.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
Everyone can be seated. Thank you. Members of the jury, thank you for your patience. We had a long conversation about the jury instructions, and I missed a typo or two after I had printed everything, and it took us a while to print everything out. I'm going to ask the courtroom deputy to come forward and pass these out to you. If you could, if you can, please raise your hands to confirm that you complied with the court's instructions during the break. All right, record will reflect all hands have been raised. Members of the jury, we are at the conclusion of the evidence and testimony in this case. The court is now going to instruct you on the law. The courtroom deputy is providing you copies of the jury instructions. Like I said at the beginning, you're going to be able to take these back with you into the deliberation room. There's not going to be a quiz or a test at the end. You don't need to memorize anything. If you'd like to read along, you can. If you just want to listen, you can. It's completely up to you. The court's going to read most of the instructions and then turn it over to the lawyers for their closing arguments. The state will go first, as they have the burden. Then the defense will go. And then the state will have the opportunity to rebut. Then I will conclude the instructions and release you for your deliberations. After the state's closing, we're going to take our afternoon recess. At that point in time, I'll have the courtroom deputy provide you that emergency number. So if you need to reach out into your family or loved ones to let them know that you are on the jury and are deliberating, you can do that at that time. With that, members of the jury, the court's going to go ahead and begin reading you the jury instructions. Instruction 3.1, Introduction to Final Instructions. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give to you. 3.2, Statement of the Charge. Sarah Boone, the defendant in this case, has been accused of the crime of second-degree murder. 7.1, Introduction to Homicide. Sarah Boone is accused of second-degree murder. Murder in the second degree includes the lesser crime of manslaughter, both of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find George Torres was killed by Sarah Boone, you will then consider the circumstances surrounding the killing in deciding if the killing was second-degree murder or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1. When the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual, ordinary caution and without any unlawful intent. Or 2. When the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3. When the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such, does not include mere bruises. I now instruct you on the circumstances that must be proved before Sarah Boone may be found guilty of second-degree murder or any lesser included crime. 7.4 Murder, second degree. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1. George Torres is dead. 2. The death was caused by the criminal act of Sarah Boone. 3. There was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1. A person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2. Is done from ill will, hatred, spite, or an evil intent, and 3. Is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. 3.4. When there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is charged, there may be evidence that she committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of second-degree murder is manslaughter, culpable negligence. 7.7 Manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1. George Torres is dead. 2A. Sarah Boone intentionally committed an act or acts that caused the death of George Torres. B. The death of George Torres was caused by the culpable negligence of Sarah Boone. Yes? I apologize. Or, thank you for that clarification. Sarah Boone I'll reread those for you. 2A. Sarah Boone intentionally committed an act or acts that caused the death of George Torres. Or B. The death of George Torres was caused by the culpable negligence of Sarah Boone. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty, without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Capable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known, or reasonably should have known, was likely to cause death or great bodily injury. 8.9. Culpable negligence. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1. Sarah Boone exposed George Torres Jr. to a personal injury. 2. She did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life, or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such indifference to the rights of others as is equivalent to an intentional violation of such rights. 3.6d, as in Delta, voluntary intoxication. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. 3.6f, as in Foxtrot, justifiable use of deadly force. It is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use or threatened use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, For you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. The law on the justifiable use, deadly force, is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to herself. Sarah Boone had no duty to retreat before using deadly force. In deciding whether Sarah Boone was justified in the use of deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself, unless 1. The threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm. Please silence your cell phones. And had it exhausted every... Out. Whoever phone is on, get out right now.
Yeah. Wow. Wow. George's mom
Members
is
of the jury, I
breaking my
apologize.
heart.
I'm going to read that over for you for the beginning.
She's
Paragraph
leaning on
1.
her boy.
The threat of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm, and had exhausted every reasonable means to escape the danger, other than using deadly force on George Torres. Or 2, in good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force, but George Torres continued or resumed the threatened use of force. Physical contact includes any restraint on George Torres's movement. If you find that Sarah Boone, who because of prior threats or difficulties with George Torres Jr., had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of George Torres, you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person. If you find that at the time of the alleged second-degree murder, manslaughter, or culpable negligence, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. In considering the issue of self-defense,
This is where I get nervous because people are emotional, and I get nervous that they won't pick up on the detail that she had to have believed these things and had to be at risk at the time of the act. Like, it can't be revenge. It can't be because he did something a week ago. And so I get nervous that, I don't know, maybe I'm being unreasonable. Maybe jurors are clear on that.
you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres.
I'm missing page 10 and 11.
I am too.
Okay. We will remedy that. Thank you, sir. Is it just your copy, Mr. Owens?
Anybody else missing 10 and 11?
We'll bring it to you, sir.
I agree, Lori, that
wait
nobody,
till I have the
that
certain
he didn't
Thank
threaten
you.
her when he was in there. She videotaped everything. Why not him threatening her then?
Thank you. Record reflect all thumbs were up. Page 11, special instruction on battered spouse syndrome. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome. 3.6G, justifiable use of non-deadly force. It is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use of non-deadly force. Non-deadly force means force not likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Sarah Boone does not have the burden of proving that she was justified in using non-deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using non-deadly force. The law on the justifiable use of non-deadly is as follows. Sarah Boone was justified in using non-deadly force against George Torres and had no duty to retreat if she reasonably believed that such conduct was necessary to defend herself against George Torres's imminent use of unlawful force. In deciding whether Sarah Boone was justified in the use of non-deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use of non-deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed the use of non-deadly force was necessary. Moreover, a reasonably cautious and prudent person under the same circumstances would have believed the use of non-deadly force was necessary. However, the use of non-deadly force is not justified if you find that Sarah Boone used force to initially provoke or threatened use of force against herself, unless the threatened force asserted towards Sarah Boone was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using non-deadly force on George Torres. Or, 2, in good faith, Sarah Boone withdrew from physical contact with George Torres and indicated clearly to George Torres that she wanted to withdraw and stop the use of non-deadly force. But George Torres continued or resumed or threatened use of force. Physical contact includes any restraint on George Torres's movement. If you find that Sarah Boone, who, because of prior threats or difficulties with George Torres Jr., had reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands of George Torres Jr., you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person. If you find that at the time of the alleged second-degree murder and or culpable negligence, Sarah Boone knew that George Torres Jr. had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use non-deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres. Special instruction on battered spouse syndrome. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that
Somebody's asking if this is going to be explained again, excuse me, in the jury room. No, but they have exactly what he's reading. They each have a copy of that in writing. And someone said, I'm making you nervous, and I apologize. I'm always nervous about juries.
Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome. 3.7, plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. 3.9, weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. 3.9 Bravo. Defendant statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1. Whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2. Whether anyone had promised her anything in order to get her to make it. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. 3.10 Rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this matter. All of us are depending upon you to make a wise and legal decision in this matter. 2. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence in these instructions. 3. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. 3.11 Cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. 2.7 Closing argument. Both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. With that, state, you may proceed.
Cacciatore's doing it?
This is a box. This is the box where George Torres was killed. It's a small box, 28 by 20 by 8 7/8 inches. George Torres was zipped up in this box. George Torres took his last panicked breaths in this box. The medical examiner explained to us that with each breath George Torres took in, there was less oxygen in this box. George Torres was murdered in this box. Ladies and gentlemen, on behalf of myself, my trial partner, we thank you for your time and attention in this most important of trials. We now have the law from the judge in this case. This is what our duty is to follow. And let's have a discussion regarding that law that we've just been read and given. The first section of note we're going to come to is called Introduction to Homicide. But this being a legal document written by a bunch of lawyers who you've seen for the last 2 weeks arguing with each other, pay careful attention to ands and ors. Remember, if an and is somewhere, we're going to need both things or all the things, and if an or is there, then only one of those things we're going to need. So, as we start out here on Introduction to Homicide, we come to the first section on justifiable homicide. And it reads, the killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time. Ladies and gentlemen, this section is completely inapplicable. It's inapplicable because George Torres was zipped up in that suitcase. He couldn't commit or attempt to commit a murder on anybody. He couldn't even scratch his own head while he was in that suitcase. Next, we turn to excusable homicide. Here we have several paragraphs. And it reads, "The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. When the killing is committed by accident and in misfortune, in doing any lawful act by lawful means, with usual ordinary caution and without any unlawful intent." Well, the problem in this circumstance for the defendant is that she took the law into her own hands. Her testimony was that when George Torres was in here, he was laughing and giggling and they were joking. And then he started to complain that he couldn't breathe. And that's when she said that she wanted him to stay in there so he could feel uncomfortable. So he could feel her grievances. Ladies and gentlemen, that is not lawful. That is not the use of ordinary caution. And that is not applicable in this circumstance. Second, when the killing occurs by accident or misfortune in the heat of passion upon any sudden and sufficient provocation. George Torres couldn't provoke anything from his circumstance. George Torres was confined to this box. Next, when the killing is committed by accident and misfortune resulting from a sudden combat, a dangerous weapon is not used, the killing is not done in a cruel and unusual manner. This fails on 2 counts. There was no sudden combat. In her words, this was laughing and joking and we're all having fun when she decides that it's going to get a little extra real for George Torres. And it fails on the second count because George Torres was killed in a cruel and unusual manner. Next, we turn to our main charge of second-degree murder. And the law informs us that to prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. I think it's important to stop right here. This sentence right here is telling us what has to be proven in order for the crime of second-degree murder to be, for the defendant to be found guilty in this case. We've been hearing all kinds of facts for almost 2 weeks now of trial. But these are the 3 facts that had to have been met by the reasonable doubt standard in order to be found guilty. Ladies and gentlemen, I submit to you that the state has proven second-degree murder beyond all doubt. And the proof of that guilt is overwhelming. But I will cite for each element just one fact that conclusively proves each of those elements beyond all doubt. As to the first fact, that George Torres is dead, well, we have stipulation, amongst other things, that agrees to that. As to the second fact, the death was caused by Sarah Boone. Sarah Boone in her own words, from the time that this case began on February 23rd, 2020, to when she took the witness stand a few days ago, was consistent about one statement. She zipped him up. She didn't zip him out. She zipped him up in the suitcase, and she refused to zip him out. 3, there was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. The law goes on to define for us what a depraved mind is, and also what an act is. And it's going to tell us that an act includes any series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another in demonstrating a depraved mind if it is an act or a series of acts that, one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself displays an indifference to human life. Ladies and gentlemen, her conduct fits every one of those things. And if there was a scintilla of doubt that this was not the actions of a depraved mind, I point to you, ING 1062, in States 17. Mr. J, may you publish States 17?
I like how he's taken them through this way.
Shallow. For everything you've done to me. Shallow. For everything you've done to me. Shallow. Fuck you. Shallow. Fuck you. Shallow. Stupid. Shallow. That's my name. Don't wear it out. I can't fucking breathe, babe. Seriously. Yeah, that's when you do and choke me. Cheryl.
Did frickin' Owens just interrupt closings? Did I hear his voice? What is going on here? Oh. Oh my. Oh. Oh, mama. She's gonna make me cry. Oh. Look at her. There is nothing from Sarah. Nothing. Oh, Mama. This poor family.
You may continue.
Sarah. Sarah. Sarah, I can't breathe it. That's on you. Sarah, I can't breathe. It's on you. Sarah. Real ransom. Now you want to give it for it extra. Because I got this. Sarah. Real ransom. Sarah. I can't breathe, babe. Oh. That's what I feel like when you jingle me. Sarah. Fuck you! Breathe, Sarah. Yeah. You should probably shut the fuck up. Shh.
Ladies and gentlemen, that exhibit removes any scintilla of doubt about the depravity of the defendant's actions. But we know from the evidence that this was not the first time she had considered killing George Torres. We know from the evidence that on January 13th, 2020, approximately 1 month prior to George Torres' murder, the defendant had a text message conversation. Please do something with yourself, Sarah. God bless you. Bless you and all of you too. I'll get rid of him. Then I'll be better. Torres. But ladies and gentlemen, in this case, the law actually specifically tells us that the intent to cause death is not necessary. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Next, we turn. I'm going to bypass the lesser included offenses because though she is guilty of those offenses as well, the law instructs us that she is to be convicted of for the highest offense in which the evidence supports, which is second-degree murder in this case. So turning our attention towards voluntary intoxication. If there was any question about the fact that Sarah imbibed alcohol on the night that George Torres was murdered. And that maybe somehow that would excuse the conduct or be some type of defense for the conduct. Well, this tells us that that's not the case. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. Ladies and gentlemen, there's ample evidence of the defendant's intoxication from watching her on the public surveillance, buying the bottles of wine with George Torres, to her admissions to drinking, to her voice that we heard on the video while she was torturing George Torres. Next, we come to defenses. First, we come to the justifiable use of deadly force. It tells us it is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone were justifiable use or threatened use of deadly force. Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. The law on the justifiable use of deadly force is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent the imminent death or great bodily harm to herself. Sarah Boone had no duty to retreat. Ladies and gentlemen, in a few moments, Mr. Owens will rise, and he is going to show you this. And this. And this.
I'm loving that he's doing this. What he's doing is addressing the very thing that I said I was afraid of. So I know where he's going, and I think it's great.
And he's going to talk in this as well about the list of grievances that Sarah Boone had for George Torres. He's going to talk to you about curtain rods. He's going to talk to you about black eyes.
even the way he's just dropping those placards almost like there's disdain, like they should just be discarded. Even his mannerisms in front of the jury here are great, and the use of the word grievances was great.
He's going to talk to you about what an awful, awful boyfriend George Torres was. And ladies and gentlemen, at the end of all of that, it still will not change the fact that the defendant is not entitled to the justifiable use of deadly force. Because as we continue to read this instruction, it tells us, in deciding whether Sarah Boone was justified in using the use of deadly force, you must consider the circumstances at the time the force or the threat of force was used. Danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed that deadly force was necessary. Moreover, to justify the use of deadly force, and this is important, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. Ladies and gentlemen, no reasonably prudent and cautious person would believe that a man who could barely fit into this box, who was incapable of movement, who was begging for his life, who was slowly asphyxiating, suffocating with each breath, would have needed to use deadly force against him. The justifiable use of deadly force utterly fails, utterly crashes like a house of cards. But there's more. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke threatened use of force against herself. Let's stop there before we consider the next two paragraphs. Some of the most critical testimony in this trial is her testimony on the stand. It was a great day. We were doing puzzles and artwork, dancing with the dogs, listening to music. Tag, you're it. Hide and go seek time. George gets into the suitcase. She comes and zips him up. They were still laughing about it. We're still laughing after he's zipped up in the suitcase. And then that's when George had the temerity to ask, George Torres had the temerity to ask to be unzipped from the suitcase. And that's when Sarah Boone decided he needed to suffer. She was the initial aggressor, ladies and gentlemen. She provoked the use of force in this case. In her own words, we were laughing and playing right before he wanted to be let out because he couldn't breathe. Paragraph 1. the threat of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using deadly force on George Torres. He couldn't exert anything, ladies and gentlemen. George Torres couldn't even exert his arm out of the suitcase. How on earth could he have exerted a force so great to justify his...
Judge, I object.
Roach.
Not really supposed to object during closing. Bad manners. So, the judge is going to want to hear Owens give something good here. But, he's Owens, so who knows. I like that he's going through each element of law so that it's not confusing. Poetic Justice is saying the objection could be misstates the evidence. Could be. Could be. But one could argue the evidence shows both. Her testimony is that his arm came out, but the evidence in common sense
Objection overruled.
says he couldn't.
This is of no help to the defendant. Second paragraph. In good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force. But George Torres continued or resumed threatened use of deadly force. Ladies and gentlemen, George Torres never got a chance to do anything. George Torres never was able to mount any aggression towards the defendant. Therefore, this paragraph is inapplicable. And the law tells us as well that physical contact in this case includes any restraint on George Torres's movements. The law also tells us, again, you find that Sarah Boone, because of prior threats or difficulties with George Torres, had reasonable grounds to believe that she was in danger of great bodily harm, of death or great bodily harm at the hands of George Torres. You may consider this fact in determining whether the actions of Sarah Boone were reasonable. Now, we're going to get to battered spouse syndrome in a moment. But again, I submit to you, this will be the opportunity for the defense to air grievances in regards to George Torres. But again, those grievances will not change the law, and they will not change the fact that the justifiable use of deadly force fails as a defense for the defendant. If you find that at the time of the alleged second-degree murder, manslaughter, culpable negligence, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. considering the issue of deadly force, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres. Now we come to the special instruction on battered spouse. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find Sarah Boone suffered from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether, in Sarah Boone's circumstances, would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony in regards to battered spouse. Ladies and gentlemen, we heard from 3 experts in the areas of battered spouse in this case. And I think at the outset, it's important to note what battered spouse is and isn't and what the law instructs us here. Battered spouse is not some carte blanche. Battered spouse is not a license to kill. The fact that George Torres, at points, mistreated Sarah Boone, did things that were worthy enough to get him arrested, to get restraining orders placed upon him, doesn't mean that she walks around with an ace in her pocket when it comes to George Torres. It doesn't mean that because he did these awful bad things, that now through the rest of time she's a battered spouse and she just has the right to kill him or to make him suffer or to punish him or to make him feel uncomfortable or decide that he needs to be confined to a box. No. What the battered spouse syndrome instruction does, it talks about the imminency of fear. And when we heard about that testimony, we heard about it from Dr. Harper, and we heard about it from Dr. Brannon for the defense. And some of the testimony was a little difficult to understand at points, but there was one point in Dr. Brannon's testimony that was very critical. Dr. Brannon talked about rule-outs. He talked about the fact that when emotions and emotional reactions are involved, like trauma and trauma-based disorders, other possibilities have to be ruled out before we can even ascribe those actions to battered spouse syndrome. Other possibilities, according to Dr. Brannon, include alcohol abuse. Dr. Harper should have listened to Dr. Brannon's testimony because Dr. Brannon completely undercut Dr. Harper's testimony. Dr. Harper relied heavily on the words of the defendant, who was abusing alcohol at the time of these events. And then you heard from the expert for the state, Tanya Warner. And her opinion was much more straightforward. Remember, Dr. Brandon did not render an opinion as to whether or not she suffered from battered spouse. Dr. Warner said affirmatively, yes, I believe she did suffer from battered spouse syndrome. But she also applied what Dr. Brandon was talking about. Other possibilities have to be ruled out as the trigger for a behavior, for an event. So, in Dr. Warner's estimation, the fact that at the time of this incident, they were laughing and joking and carrying on meant that the trigger was not domestic violence or some threat. In the defendant's own words, the trigger was him wanting to get out and her being reminded of the bad things that he had done to her. That's not imminence of fear. That's reminder of bad things a person has done. And again, even if you were to believe that she was battered spouse triggered at the time of this event, it still does not save the day. Because all the battered spouse trigger law tells us is that it goes to that imminency requirement. It doesn't say there's no imminency requirement. It doesn't say that, look, if you're suffering from battered spouse and you're triggered by battered spouse, then, hey, there's no more imminency requirement, do as you wish. It just gives the ladies and gentlemen of the jury another thing to consider in determining whether or not that threat was imminent. And we know from the evidence, we know from the videos, there was absolutely no threat. And we know there was no threat because George Torres never got out of that box. He was never got out of that box until sometime on the early afternoon of February 24th. Mr. J, can you please publish from stage 21?
I'm going to go to court and I'm going to tell the judge, listen, my fiance has nothing to do with this. It's all my fault. We were both drinking and got out of hand. It's an isolated situation. It has never happened before. I love my fiance. She's a good woman. For being in trouble in her life, she has a 7-year-old son that she loves and cherishes.
A blind Boston Terrier.
She has 2 dogs. One is blind, one is deaf. She goes around and she's driving and sees an animal that's injured. She'll stop in the middle of the street, no matter what kind of traffic it is, just to make sure that that animal doesn't get injured any more than what it already has. We both love each other. We both live together. Yes, every relationship has their arguments, but we are not the type of people that you guys are portraying us to be.
She especially.
Especially her. So please, if you can,
Dismissed.
dismiss this case.
Closed.
Drop it. She is not the type of person.
Good person.
She's a great person.
Angel.
I know she'd be an angel. She's close to it.
Best thing that has ever happened to you.
Yes, ma'am. And I love you to death. And I hate that we're going through this right now.
Sonnet.
What?
And it could.
I love you, baby. Whatever you want to say. God will prevail, and He will take us out of this situation. Love you.
Clearly, George Torres is dominating the defendant. Clearly, George Torres is the one telling the defendant what to do. Clearly, George Torres is the one calling the shots at 4748 France Lane. Ladies and gentlemen, are we so sure that George Torres wasn't the person suffering from battered spouse syndrome? Next, we're going to come to the justifiable use of non-deadly force. The language and the arguments are pretty close to what we've already heard in the deadly force instruction, including the key language that it requires a reasonably cautious and prudent person under the same circumstances would have believed the use of non-deadly force was necessary. Ladies and gentlemen, I submit to you that this was not a case of non-deadly force. George Torres lost his life as a result of these actions. We have heard the testimony of Dr. Sarah Zadovich, who described his cause and manner of death, who described the mechanism of death, how that oxygen dissipated in that suitcase. And when we also look at the imminency, we heard in opening statements by Mr. Owens that, the big threat in this case, the awful threat, was in the magic 9 minutes between the video at 11:12 that she took, torturing George Torres, to her follow-up video at 11:23, after she had moved the suitcase. Mr. J, that you publish from States 17, IMG 1063.
Watch that zipper because it's closed. She said she left it open during that gap, that 11-minute gap, that she never touched it again.
It was a short video. Well, what's one of the things that we notice by this point? You can hear how loud George's voice is on the 11:12 video. But now, roughly 11 minutes later from the time that started, you see that the makeshift coffin that he's in has been moved. And his voice now is softer. The life is draining from George Torres, and it's evident in that video. And that, ladies and gentlemen, is evidence that there was no threat in the magic 9 minutes that was not recorded. There was only George Torres in this box, slowly being killed. Next, we come to weighing the evidence. This instruction tells us it is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witness acted as well as what they said. Some things you should consider. Did the witness have an opportunity to see and know the things about which the witness testified? In focusing on the defendant, absolutely. Two people walked through the front door on the evening of February 23rd, 2020 at 4748 France Court. George Torres and Sarah Boone. But only Sarah Boone ever walked out that front door alive. Did the witness seem to have an accurate memory? This is an emphatic no. And the litany of her intoxication in versions of events is evidence of that. Was the witness honest and straightforward in answering the attorney's questions? I would submit to you she wasn't. 4, did the witness have some interest in how the case should be decided? Clearly, Does the witness's testimony agree with the other testimony and other evidence in the case? And I would say largely no. Because on the issue of whether or not George Torres could have threatened her the way she says that he did, the answer is clearly no, and we know that from the forensic data. We know that from the items itself. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? In regards to the defendant, it's almost more appropriate to ask about the time she did make a consistent statement. You listen to her version of events on the 911 call, on the body cameras, on her first interviews with law enforcement, and then you hear her in her next interview the next day with Detective Kopsel and Detective Lowen, and more details come out. Things change. First, she was never intoxicated. Then she was intoxicated. Then there's just the whole fact of she omits the fact of, oh yeah, he was actually trying to attack me. Oh yeah, I was in fear for my life. When she said at every turn, no, it was just a great day. We were having fun. Oh my God, I can't believe this. We were doing good. The only stress we had was about jobs. And now, 4.5 years after the fact, it's time to come up with a new story. But ladies and gentlemen, I submit to you that the truth does not change. The facts do not change. The videos do not change. And on any version of events that the defendant has given, they all add up to the fact that there is absolutely no doubt that she is guilty of murder. I ask you, ladies and gentlemen, do you have any doubt about the defendant's guilt when she described using that baseball bat to hit George Torres's fingers back in the suitcase when he attempted to save his life? Do you have any doubt when she is given how many versions of events in this case? Do you have any doubt after hearing the testimony of her neighbors about the loud crash and the arguing that night? Do you have any doubt after hearing the testimony of Dr. Sarah Zadovich? Do you have any doubt after watching the videos of George Torres being murdered and her laughing about it and talking about the fact that he cheated on her? Do you have any doubt after reading the text messages from her phone? After seeing the videos of how she controlled and manipulated George Torres? And if you say, Mr. Cacciatore, I still have a doubt, well then the law asks you, is that doubt to an element? And is that doubt a mere possible doubt, a speculative, an imaginary, or a forced doubt? I submit to you the idea that she had to do this because she was a battered spouse is an imaginary doubt. It's a doubt born from the imagination of Sarah Boone. It is not a reasonable doubt. But if you find yourself back in that deliberation room and you are just trying to think of some way in which the defendant is not guilty, just searching, struggling for that way, that also is not a reasonable doubt, ladies and gentlemen. That is a forced doubt. Ladies and gentlemen, I'm confident that when you read the entirety of those jury instructions and apply the law to the facts that came out in this case, that you are going to come back with the only lawful verdict, which is guilty as charged, second-degree murder. Thank you.
He's disgusted with Sarah. You can see it in his face.
Members of the jury, it is 4:04. As I promised, we were going to take that afternoon break before the defense proceeds with their closing argument. You're going to leave everything behind. Similar instruction that I've given you before. Please don't conduct any independent investigation, research as to the person, places, thing, or charge involved in this case. And do not have any discussions among yourselves or anyone else. We'll bring it back in about 15 minutes. Thank you very much.
All rise for an accident.
I need to take 3 minutes. I'm going to leave the screen up, leave the chat up,
Y'all may be seated. Thank you.
but I just need a minute.
You got a motion.
Okay,
And
may
I'll
proceed.
come back. Oh, no, I guess I'm not getting a
Sarah
minute.
Boone's entitled to a fair trial. I think that right has been compromised here today. I don't know who scheduled to put the two detectives on the front row with the Torres family, who the family of the victim. But they had to have known to tell them that the suitcase video.
Oh my. Okay, I'm trying not to scream at you. I am so mad. He is just horrible. Horrible. Somebody asked in the chat. Somebody in the chat here predicted this. Someone in the chat said, "Oh, is Owens gonna ask for a mistrial because Mrs. Torres was taken out?" And I thought, well, that's silly because I mean, it's the victim's mother. And here he is actually flipping doing that. So did the state warn Mrs. Torres that this was going to be terribly upsetting? I'm sure they did. I'm sure they did. And maybe the family wanted to be there. The mom wanted to be there to bear witness for her son, and maybe she thought she could handle it, and she couldn't. Are you telling me that a mother's grief is a bad thing? Right? Let's not let the jury see that. That's real. But we can hold up pictures of Sarah and just show Sarah's side of the story about how horrible Mr. Torres is. We listen to Sarah's narrative about how horrible Mr. Torres' family is, except now the jury sees them sitting in the front row and they're not horrible. And that poor, poor woman. What is this, Owens? How dare she have grief? Sorry, I'm so mad. I'm going to stop ranting and I'm going to let him go on. But I am ticked, and I am sure a number of you are too.
Which has been around for 4.5 years, was going to be played during opening statement. And the state attorney's office or the sheriff's department had to advise them, or the victim's advocate had to advise them, that if they couldn't take it in front of a jury that's trying to decide the case, they needed to get out of the courtroom. Now, what happened here today should not ever happen. There should be safeguards in place.
Oh, I have words I can't say on YouTube. There should be safeguards in place. God forbid that a victim and surviving families feel anything. Is that it? So Sarah gets to just do what she wants and make accusations she wants, and no one is allowed to feel the consequences? You know who doesn't feel the consequences of her action? It's her. Everybody has suffered because of her. But geez, this should never happen. Victims, don't you cry. Don't you be upset. How dare he? This is ludicrous. And yeah, I know that, some legal eagles can make some arguments about this, but you know what? These are human beings, and this should never happen. Well, you know what? They try not to have disruptions, but these are people. Oh, Owens.
There's no room for this after 2 weeks of murder trial for something like that to happen. One of the Torres members of the family audibly, during the 2-minute suitcase video, expressed some kind of emotional reaction. I look back, he or she were bent over in agony, physical pain. The physical pain followed the audible announcement. You can't unring that bell. That's their responsibility to ensure that kind of thing doesn't happen, especially when they know they're going to show a video and the family of the victim is on the front row. I've never heard of such. I asked for a mistrial.
Response.
I've never heard of such a request. The victim's family has the right to be here. They were advised as to what will be used during closing arguments. I cannot make a decision for the victim's family and the homicide survivors as to whether or not they believe they can handle it. She clearly, or he, I don't know, couldn't, and I believe the appropriate thing was done. They left the courtroom. But again, to say this is intentional sabotage and all the accusations that continuously get made are unsubstantiated. And it does not warrant a mistrial. People get warned, and sometimes they misjudge their own emotions. I don't understand what test we are expected to run on homicide survivors. So the motion should be denied.
Motion's denied. Jury's going to be back in about 13 minutes, counsel. So we'll reconvene at that point in time.
Could the state put the suitcase back in the morning?
Yeah, can we clean the well from the state's materials, please? Thank you.
Yeah, get the suitcase out of here. Oh my gosh. Okay. Guys, I need about 3 minutes, and I'm going to come back. I need to take care of Watson and to get a drink of water, and I'll come back and be right back in the chat. I'm just going to leave the chat open, okay? And thank you for bearing with me. Okay, I'm back. And I want to check in. I'm going to switch screens again so I can see the chat better. Check in with you guys. Man, this guy ticks me off. Joe Smith, Mama Torres, my heart goes out to you. Yeah, man. Yeah. So someone's saying, I have told friends and family about what Sarah did to George, and after 4 years, they still cringe and definitely don't want to see the video. Mrs. Torres did nothing wrong. And, families have different ideas about what they think they need and what they think they can handle. Some families want to know everything. And we warn them sometimes, look, you know what? Maybe you don't want to look at this. And a lot of them insist, no, I need to know what happened to my loved one. I can handle it now. And maybe she thought she could, and she couldn't. Paige, I was stricken and I'm a stoic person. Yeah. And yeah, Mr. J was right to say, what type of test are we supposed to apply to homicide, to survivors? Really? Really? I mean, of course, Sarah Boone, of all people, would want everybody to not have any feelings except what she dictates. Good heavens. Joe Smith, we need to breathe, family. Yeah. Someone's saying no one's going to weep for Sarah. Her son might. I don't know. Oh, I just saw in the chat someone said that she gave an interview saying she hadn't seen the video. Kimberly is saying that I got to stop apologizing for expressing what all of us are feeling. Yeah. Yeah. I mean, if I wanted to be really cold, I could see an argument and all that. But we live in the real world. People are human. People have feelings. Can I tell you a story, like a personal experience story? Anybody interested in that? Or do we want to talk about what everybody's going through here? Sarah had one friend that didn't work out. Yeah, Linnell, she heard her child pleading for his life. Yeah, okay. There was a time, if they come back, I'll just stop my story. So remind me if I don't finish it. There was one time I had to advocate for a police officer who was seriously injured in the line of duty. I'm talking life altering injuries. His life was destroyed. And this was as the result of a criminal's actions. On the morning of the bail hearing, of course, every officer who could get away showed up in court. The courtroom was full. And the defense complained that could appear like intimidation of the bench. And so the chief said, look, you can go to hearings or whatever, but no one on duty, no one in uniform can go and sit in that hearing. And the inspector took it a step further and said, none of you can go. Nobody could go. I could go, and there were a couple of other officers who could go because they were involved in different ways. And I was angry and I argued with the inspector, and I was, when he gets so mad and you're not allowed to be yelling, so you almost want to cry. And I was looking like I was going to cry in this argument. And this inspector said to me, "We do not cry. We do not. Don't eat, don't you dare." These guys who worked with this fellow were so distraught, and some of them had witnessed what happened to them, and it was traumatic for them. And just because they're police officers doesn't mean they're not human beings. And sometimes, systems expect people to act like robots, and we're not. So, if a group of police officers who are used to all this stuff struggle, you think someone's mother isn't going to struggle? I think none of them ever forgave that inspector either for the way he acted. Miriam says there should be consequences for lawyers who accuse other lawyers on the record without evidence. Yeah, Owens put this right on the state, as if the state somehow orchestrated this. And this isn't the first time Owens did this. Tracy, what exactly did Owens say before his mom was led out? I missed it. I don't know what he said. I heard his voice. And then there was the video stopped and there was the commotion. And we saw Mrs. Torres just crumpled over. I mean, parents, if that was your boy, if that was your child, wouldn't you be the same? And she's sitting through, the Sarah Boone freaking circus. Somebody says, I wish the jurors could hear your analysis. Yeah, I think they'll be okay. Jay-Z says the state has zero control over others' emotions. Crap happens. It's the real world. Kimberly says Boone wants to admonish and control the gallery, just like she admonished and controlled George. Nothing has changed with that witch, and Owens is her male mirror image. Yeah. Sandy is pointing out, and she has to look at Sarah. She has to look at the monster who did this, sitting there feeling nothing. Think about it. If you hurt someone, if you cause their demise, even by accident, wouldn't it be kind of a wreck? Wouldn't it be hard to look at that? There's nothing from Sarah. Nothing. All about her. Always has been right from the beginning. She'd rather have a smoke and a Dr. Pepper than call 911 or do CPR. And her version of love? Man, that's scary. Oh, you're saying they're back? No, I'm not seeing it.
Absent during the closing. It seemed to be minor in nature. However, I'm advising everyone that at this time, if you believe that you cannot control yourself or your emotional responses during the defense's closing argument or any rebuttal by the state, I'm going to politely ask you to excuse yourselves at this time. All right, thank you very much. All right, thank you very much. Mr. Owens, anything else, sir?
No, sir.
All right, state.
We're ready.
All right, let's bring back in our panel.
Now we got to hear from the snake, right?
making their selections.
Okay, thank you. All can be seated. They're making their dinner selections. We'll just give them a couple minutes to do that. Thank you.
Okay, what are we doing, everybody? Because we're all going to be annoyed. We know we are. So what are we doing to gear up for this and take care of ourselves? Or what do you want me to do for you? Let me ask you that. Al saying deep breaths. Oh, Marvin, I'm so sorry. Someone in the chat had a death in the family. I'm so sorry to hear that. Oh, okay. So to cope, let's make jokes about Owens. Yeah. I'll pause from time to time and read them out if you want. Oh, someone's saying Chelsea's back in court? Good. I could just put him on mute and just, like I said the other day, I'll just put him on mute and read Shakespeare to you. I won't really, because some people actually want to hear what he has to say. Oh, Chelsea's sitting with the family. Good for her. Good for her. You do get close to victims' families over these things? Catherine's, yeah, we'll all be annoyed together. We'll just commiserate. I mean, look, in the chat here, we have somebody whose handle is pretend judge. And that comes from one of Sarah's letters. You know what else we could do? We could imagine Cashman, Bankowitz, and Hobson sitting around having a Sarah Boone trial watch party and laughing their butts off, being glad they're not in here. Oh, we could, somebody suggested in the chat, we could do our own closing. I think Jay did a good, or sorry, Cacciatore did a good job. Jay will get to speak after the defense closing if he wants. Oh, someone in the chat said, we excel at everything. So, okay, so let's take a stab at Owen's clothing, or closing. Wah, wah, wah. Believe her lies. Wah, wah. Let me throw some mud in the water. Let me complain. Let me make a word salad. Don't listen to the prosecution. Something like that, right? It was a good day, Jay-Z's saying. Somebody says Owens is going to end up finishing a 1.5 liter bottle by himself. Yeah. At the beginning, before the prosecution opening statements, I was actually a little bit worried about Mr. J. I was watching his respiration was way up and his color was a little bit off. And I thought, oh no, but he's fine, it looks like. Oh, Jane is saying, yeah, I wish we could post GIFs here. Yeah. Could you imagine the memes that we could come up with? Like the Owens memes? Kim, wow, wow, he stole my posters. Yeah. Yeah, Owens will have his pouty toddler face. Wonder, Matcha, we're waiting. The jury's busy with something, I guess. Someone saying the lack of emotion in Sarah has the commenter gobsmacked. Frauke says, do we want memes? Yeah, maybe not. Matuko, you're eating an ice cream sandwich? Somebody says like Mr. Owens is the Grinch. I just, you know what? When I get annoyed, I am just going to, this is what we should do. Just picture him in a giant diaper with a binky and a little security blanket because he whines so much. Yeah, Giovanna. Oh, Nikki, you don't know what an ice cream sandwich is? Oh, they're good. It's like, well, somebody in the chat can explain to you. Martha, I'm imagining them in a giant playpen. Yeah. Yeah. Just imagine everybody at defense table right now. Just imagine them all as cartoons. And Sarah has little horns, that she's trying to cover up with her hair. Somebody saying Owens steals my humor, so I can't even think of a joke. Don't worry, this chat is awesome. The people here are hilarious. Somebody in the chat's asking what's going on. We're just waiting. The jury had to fill out a form or something like that, so we're just waiting for them to get back. Linda's asking, is Owens coming on? Soon. We're just trying to think of how we're going to cope with our annoyance of him because he's just so irritating. I still think he's not as bad as Lally. Susie's asking, do we think the jury will deliberate over the weekend? Well, they won't know. So no, if they don't come to a verdict today, they go home and they'll come back on Monday. Oh, dinner order for the jury. That's what they're filling out. Yes. Yes. Somebody's saying, why on earth is Sarah still shuffling papers? Yeah. It's not like there's more. What is she doing? Proofreading their closings? Owens is wordier than Lally. At least Owens, yeah, maybe he is. And he does repeat himself a lot. But at least you can follow Owens's arguments. Lally just goes, I don't know. Lally just goes off with the fairies sometimes. I don't know why Lally irritated me so much. Maybe I shouldn't be so irritated, but he just did. So Rel is asking, who thinks we're going to have a verdict today? How many of you think we're going to have a verdict today? Seeing somebody saying verdict in 2 hours. Yep, there's only 6 jurors. So it's not like we got to convince 12. Kim saying, "Oh, you think Sarah's grading the closing statements?" So Anita self-soothing with the documents. I think that's more likely. Oh, Burgett's Owen's closing. I must be tired. I'm not even speaking. So Burgett says Owen's closing will be start with, "Ladies and gentlemen, please leave all the facts aside." So other people are saying yes, there will be a verdict today. Somebody says Owens is preparing for his next objection. He goes next. Maybe he'll object to himself. Oh, Monday is Brian Boone's son's birthday. So hopefully she is convicted today and not on his birthday. No, Monday wouldn't be perfect because the boy hasn't done anything wrong. That would suck for him. She doesn't care. She doesn't care if it's his birthday or not. She only uses him when he's useful. Criminal Minds says Owens is saying, "Where is Miss Trial? MISS trial."
I don't know if that is allowed by the court or.
Anything?
Been allowed since I started practicing in 1997.
If you want to split up your closing between the two of y'all, that's fine by me.
Well, I intended on doing the closing, but when I finish, Mr. Henderson wants to say something. I may ask him to.
I've never seen it done that way. I've understood the sandwich can be broken. I've never, ever seen a single closing argument split by another attorney.
If it's a discretionary issue, I'll leave it up to you, sir, on what you want to do and how you want to present your closing.
Burgett thinks the case is clear like a glass. I think it's clear. I think it's obvious, but that's just me. There are people out there who might not. I don't know. I don't know. We might get a verdict today. We might. Phoebe says, "Yeah, Owens always has to push the boundaries." Yeah. I can deal with Henderson's arguments. At least I understand what he's talking about.
Reasonable. Who would be objecting during rebuttal?
Mr. Owens.
Okay, there you go.
Mace is saying, yeah, the defense has to try anything to distract the jury. Yeah, don't look at the facts. I'm seeing your comments. Thank you. I saw someone say, "What are the police talking about over there?" Were deputies having, was there an issue and I didn't look at it? Catherine, I don't think Sarah cares whether it goes over to her son's birthday. I think if she can use anything for sympathy, she will. But she doesn't actually care. She just, people like this will know that you care and try to exploit the goodness in you. They exploit your empathy. They exploit your reasonableness. She doesn't have any of that on her own. Her son wants no contact. Yeah, I don't blame him. Susie's asking, why are there only 6 jurors? Because they're allowed to do it that way in Florida. Vicinator says, I think it will be a quick verdict. The video is clear. She knew what she was doing. She liked doing it, and he did nothing to her. Yeah, it's a very clear, concise way to put it. Yeah, Sarah would rather do the closing arguments herself. No malicious, unintentional. They're not, someone's asking, what are they discussing? Nothing. They're waiting for the jury. They're coming in now. Giovanna says, my finger's on the mute button. Someone asked if she's smirking. Sarah's not smirking. She's trying to smile
State, you recognize our jury.
sweetly at the
Yes,
jury.
Your Honor.
Defense, do you recognize our jury? Thank you. Y'all may be seated. Members of the jury, for one of the last times, if you could, please raise your hands to confirm that you complied with the court's instructions. All hands have been raised. Members of the jury, at this time, the defense is going to proceed with their closing argument. Similar to the state's closing argument, these are not evidence. These are just arguments, and I ask you to pay attention to them. Thank you. Mr. Owens, you may proceed, sir. Yes, sir. Thank you.
Ladies and gentlemen, good afternoon. Y'all know me, I'm James Owens, along with Tony Henderson and the girls. We're all from Milton. I think y'all figured that out, that we were from out of
Let me
town.
introduce
Santa
the
Rosa
band
County.
to you.
It's Northwest Florida, close to Pensacola. And my buddy Kevin Beck, he's a longtime friend, he's from New Mexico. The team, the defense team, is here, and we're here to represent Miss Sarah Boone. And we feel confident that we're going to be able to show you why she's not guilty. Okay? And I'm going to take my time. I've got some notes. I'm not the most organized person in the world. I've got some exhibits that we're going to show you. And then we got a couple of videos at the end. Okay? And we're going to try our best to help you make the right decision. Okay? But yeah, Milton's a small town.
Objection. Relevance.
Overruled.
Tell you how small it is. 7 miles away is another small town called Pace. In between that is a Walmart.
Well, where is he going, you guys? Let me introduce myself. I'm P.T. Barnum, and this is my circus. Oh, wait. And yeah, we have a band. Here's my circus band. Members of the band. On drums, Mr. Henderson. Conductor, Sarah Boone, right? Like, and now he's like, and we're from Milton. I'm from Milton, and it's a small town. Hello? Hello, who is this about? Is this like a free ad? Right? Come and find us in Milton? What is it about him? What? I'll keep going and see where he's going here. This is bizarre.
Very small town. We didn't know what to expect coming down here to Orlando.
Relevance.
Judge, I'm allowed to.
I'll give you a little bit more for intro, but then we need to get into it.
I'm going to get into it, but I wanted to say, it's a small town, good people. We've been down here 3 weeks. We didn't know what to expect. We've been surprised. From
Objection. Improper argument.
Mr. Owens, approach.
Don't blame us if you think our client is a monster. Oh my gosh. We didn't know what to expect. Milton, people are good there. And that's a trick, by the way. We're good people and we support this person. Therefore, you should believe that this person is also a good person because we support her. And then he goes into, oh, we were surprised.
Objections overruled.
all I wanted to say is just since we've been here, we've been treated with respect and hospitality, and just like we've been helped. We appreciate that. Now, I'm going to do some reading, and then I'm going to do some talking. But ultimately, this is about justifiable use of force. That is a legal defense in Florida. We as citizens, the law is designed to protect us from defending ourselves, to protect us from potential attack.
Where was Mr. Torres's protection? He was allowed to stick his finger out of the suitcase, not that he actually could or did. So he's now, here we go. This is going to be an appeal to emotion. The law protects us. You have a right to defend yourself. Be scared. You don't want that right taken away. Make it personal about you. It's about Ms. Boone.
And you were the only ones, in this case, because Sarah Boone was arrested, that's going to be able to look at it critically and objectively. Objectively. Not like the state attorney.
Objection. Improper argument.
Overruled.
Objectively. And the law in Florida gives y'all the power and authority to do that. The state attorney can't make the decision. They can't make the decision. They can try to influence you. And we're going to talk about some of the things they did here in this trial. And some of the things they said.
Objection. Objection. May we motion?
Yes.
Hello, the state is not on trial. And what did they do? They showed the evidence. So you guys in chat predicted exactly that. They're going to distract, I think it was Scully said they're going to distract the jury. Right? Look over there. Squirrel! That guy's bad. Therefore, my client, you should just ignore what actually happened, the evidence. Ignore that she lies. Come on, you guys. The state has done nothing improper. In fact, Mr. J, I noticed, is very by the book. Yes. I'm just country boy. Okay. Tracy's like, I'll be watching the chat from here. Yeah, the chat is great. The chat, you guys are going to keep me sane, I'm telling you. Pope 50. Squirrel, where? Zen Scout says this is the game. Oh, yeah, Owen's introducing the girls. Yeah. Isn't one of them actually a lawyer? The girls. We'll keep each other's. We're just going to keep laughing at them.
You may proceed. Objections overruled.
Thank you, Judge. They've got their side, their position, we've got our side. So we're going to talk about that. But, and we're going to talk about justifiable use of deadly force and non-deadly force. But either way, however you rule, it still justifies her behavior. And the result is not good. Now, I don't believe there's anybody...
Objection, proper argument.
Overruled.
Objection to approach.
Yes.
It really is bad etiquette to object during closings, and now Mr. J is doing it. I suspect Mr. J knows what Owens is up to, maybe more so than we do. Somebody said the village of Milton just changed their locks. Yeah. Yeah. Owens is irritated. Yeah. Yeah, he has a plan. His Owens' plan is psychological. It's not based on fact. And he can't misstate the law either.
I think you will find from considering the evidence in this case that there is no doubt that Sarah Boone is a victim. That Sarah Boone has been traumatized. That Sarah Boone is still traumatized. And the reason for the trauma is George Torres. The reason for the trauma is George Torres. From the positive things about the man that we've seen on video to the positive things Sarah Boone has testified about him, to the violent monster he becomes. And I mean monster, because it was repeatedly. And what happens the next day? Man, I don't remember. I was drunk. I don't remember. That's the gaslighting. That this young woman, vulnerable woman, with nobody, just starving for love, starving for attention, and seeing the good in the man. And it was good. But every day was on the balance. She measured every day, depending on how it started and then how it ended. And that's the way she had to live her life. Day in and day out. Day in and day out. Dr. Harper and Dr. Brandon talked about trauma. Dr. Harper spoke of the veterans that she had treated for post-traumatic stress disorder.
So he's going to talk about veterans and in general, not Sarah Boone. And what he called Mr. Torres is pretty disgusting. You okay, everybody? Okay. I'm seeing a lot of laughing and joking in the chat. Good for you. Keep laughing at him then.
I don't know if you remember her testimony. But she spoke about some of the veterans that had been in the war in Iraq. You know, and people in war a lot of times get post-traumatic stress. It used to be called shell shock and other things. But people in wartime, or police officers will get post-traumatic stress. And a lot of them come in, the males come in with this bravado, oh, I'm all right. I'm all right. And so, that's why Dr. Harper was talking about the veterans, that's what they'll do. But you've got to spend time with them. It just can't be one session. And you've got to run post-traumatic stress testing, which tells whether they really have post-traumatic stress. And we all probably have experienced some trauma. All of us have lost some loved ones. And it's awful. You're in shock. You can't believe it. It's disbelief. You don't sleep for days. And eventually, you have to go back to work. You take a week off. Life has to go on. Life has to go on. You go back to work. Kids are in school. You get a little time. Right? Time heals. Right? These veterans that come back from a deployment, they get back, they get some semblance of normalcy. They may or may not get some treatment, but time helps.
So I don't know. He's talking out of his butt. Okay? He's talking out of his arse here. Because that is not actually true. None of that was testified to. Time does not heal wounds. And I'll tell you, if you've had trauma, some of you know this, nothing gets buried dead, it's buried alive, right? So it's not time that heals the wounds. It's what you do with that time. It's what happens in that time. He's just talking out his arse. For what? To distract the jury? Even if she has PTSD, even if she has BSS, even if she has... Just give the list. List everything. Even if she has everything. None of it justifies what she did. None of it matters. He's just going to irritate the jury for a little while and hope that maybe they forget about what they just heard or he throws enough mud in the water.
Time heals. Everybody. It helps. Just time. Overcoming a divorce. Overcoming a death. Whatever trauma. Sarah Boone had no break. No break. Learned helplessness. Just giving up. Just giving up. I can't get out of this situation. They broke up.
Whoa. How many of you think this is going to backfire? After seeing her tormenting Mr. Torres while he sits curled up in a ball on the floor saying, "Yes, ma'am." Right? This is going to backfire. Frickin' good.
Go about 2 days. She go about 2 days. Texting and calling. Just learned helplessness. And it's, in the manual. Battered spouse syndrome is not. But what did you hear Dr. Harper say? She suffers from post-traumatic stress. That is a mental disorder. You are actually undergoing the psychological effects of post-traumatic stress. You're not in your right mind. And it's repeating itself. It's repeating itself again and again, day in and day out. And when you look at this law, that's what you have to apply. someone in Sarah Boone's shoes when you're deciding whether her conduct was reasonable. Got a bunch of notes. Not that, it was something I wanted to read.
Read out of the book called Terrifying Love that your client quoted on the stand.
Where did I put it?
Most people with mental illness do not hurt anybody. Just
Sarah Boone's long-term exposure to abuse created a state of learned helplessness and diminished her capacity to assess risk, especially in moments of heightened stress. The cyclical nature of this violence, the tension building, the battering, the contrition phases, caused Sarah to be trapped psychologically in that relationship. Due to this clear abuse, Sarah Boone had a reasonable belief of imminent harm under her state of mind. George Torres had a history of violence against Sarah, and as a result, Sarah Boone's actions were the result of fear conditioned by abuse she endured over time. The cumulative effects of long-term abuse, as we saw her behavior on the 2-minute suitcase video, is a trauma response. Sarah Boone acted out of a sense of preservation. While tragic, it was not driven by malice, but a mind ravaged by abuse.
What? What? F you? That's my name. Don't wear it out. F you? I can't breathe. Shh. That's fear? That's fear? Is that what he's saying here? That's fear and trauma? Really? So I guess that every violent criminal who's ever experienced anything bad, well, we'll just say it's all fear and trauma, and so just let them all do what they want. We'll just going to make it that way, right? Right? That's essentially what he's arguing.
And I'm going to ask you to try to understand. Try to understand. Sarah Boone, being emotionally and psychologically broken, whose actions may have been misguided attempts at survival but not murder. Imminent danger, her response reacted to that belief. It's somebody suffering from the long-term psychological effects of domestic violence. Who spent a lot of time? Dr. Brandon. You remember him. He was the first expert on trauma. Took some notes. Kevin Beck, you remember, did the direct examination of Dr. Brandon. He was from down in Miami, I think. He talked about the trauma, that you cannot escape from the abuse, so you develop coping skills to protect yourself, knowing that the bad things will happen to me. It changes your behavior, not only your behavior, but your thinking. Your subjective thinking about fear and what to do. And if you remember, Dr. Brandon said it's all about that person's perception. Okay? A lot of times they will self-medicate with alcohol or drugs. A lot of times they suffer from anxiety. Basically, he said the trauma ends up being terror because you do not know what to expect. You do not know what is going to happen that night. It may be a great night. You may drink, and both of you have a great time. He falls asleep, passes out, you fall asleep, passes. But it may turn But depending on his mood, I don't know if you could tell, she would try to placate him. Dr. Brandon said, you know, when you're trying to evaluate somebody, it takes time to get them to trust you. And the ultimate goal, he said, is to be a behavioral detective. If you're a forensic psychologist, is to be a behavioral detective. And the ultimate goal is to put yourself in the abused person's eyes so you can better understand their world. But ultimately, it's their perception of danger. Their perception of danger is what you have to look at. What a reasonable person would do under their perception of danger. Now, I want to go on. Trauma experts explain how victims' reactions in moments of stress are the product.
Something's happening in chat, and I want to address it. I just want to say I see you. Those of you who have suffered trauma, those of you who have been diagnosed with PTSD or complex PTSD, I see you. I know, we know that doesn't mean you're running around behaving like she does. It's horrible to suffer with that. It's difficult. For him to imply that it means that you're going to be so out of it that you're going to run around being violent, I think does a disservice to everyone who has suffered with this, because it adds to the stigma. It adds to an erroneous perception that people who suffer from this are somehow broken or dangerous. They're not. They're not. They're hurt. So I just wanted to say that. I see you guys out there with PTSD. I'm with you.
Of the damaged psyche. Her actions, although tragic, and it was a tragedy, George Torres lost his life in that suitcase. It's a reactionary response to sustained trauma. It's as if Sarah was acting out of a deeply ingrained fear and helplessness developed over the years. So it's a desperate need for survival, but battered women do things to keep the peace from time to time. And when they feel like they have a small portion of momentary power, they may enjoy that by vocalizing their position to the abuser. Sarah Boone's not perfect. Sarah Boone would argue with him, talk down to him. Some would say was somewhat abusive to him. Sarah's not charged with that. Sarah Boone is not charged with that. And I want to read you something on that subject. Essentially, I don't know where it's at, but I'm going to have to come back to it.
Is he really
But essentially what it said was eventually
Damn it, Margaret.
It's been a 2-week trial. I got a bunch of notes. I'm trying to get this right. I know it's important. What I wanted to say was someone can be mean and angry and hateful and intoxicated and still be abused. They're not mutually exclusive. And mutual abuse exists where one is abusive towards another. And eventually the victim, Sarah Boone, trying to fight back against the abuse, became verbally abusive. While the victim has committed verbal abuse, it is important to remember that they, Sarah Boone, are the victim and have been pulled into an extremely vicious cycle where they are trying to survive.
Darvo. The victim in this case, not that anyone forgot, I just want to state it, is George Torres, not Sarah Boone. Sarah Boone is the one who murdered George Torres.
Sarah Boone intentionally left George Torres in the suitcase, which was the act of a battered spouse syndrome woman. She went up to her room, she fell asleep or passed out. These actions are disconnected. Ultimately, she didn't let him out because of her fear that she knew if he got out in that moment, what he would do. That's real fear, that's real trauma that she was experiencing at that time. Now, I talked to you about force being used, and I think I talked to you about blocking an attack using a physical restraint like the suitcase to block somebody's attack. And the example I give, I've got a couple of examples that may or may not apply. Let's say you're in a bar and you've got your buddies and the other guy's got their buddies and they're drinking and it ends up being an argument between two of them. And you realize that these two are fixing to get in it. Well, one of your buddies comes around on the other side and grabs the guy before he's able to strike him, right? So you're committing an offense on this guy, but it's a restraint. It's a restraint where you grab him by the neck.
Dude, that's assault. You can't do that.
So yeah, you're committing an act, but it's designed to defend another, which is legal.
He was zipped up
Or let's
first.
say you have a situation where you have a police officer and he's on patrol. You know, he's in uniform, he's wearing a firearm, and of course he's got the bulletproof vest. And he's called, he goes.
Good Lord. Don't. Okay, I'm going to be swearing. I'm going to put the mic on mute because I'm going to be swearing. Are you freaking going to compare Sarah Boone to a police officer? Are ya, pal? Really? You're just going to cover every base, right? Everybody you can insult, possibly. That's what you're going for. Okay.
To a call where there's a suspect that may be armed. A suspect that may be armed. And so he gets there, he gets out of the squad car, he's walking around. Of course, he's taking out his gun because he realizes he may be armed. And eventually he sees the suspect, and the suspect reaches for his waist. Now, in that moment in time, that officer has to make a decision. Am I going home with my family tonight? And I asked Dr. Werner about this Vaseline thing. It's called fear response or fight or flight. You know, those decisions are made, it's instinctive based on your set of circumstances. She instinctively reacted to her unique set of circumstances to save her life or save herself from.
Instinctively reacted. Yes, she did. But it wasn't to save her life. You see, it was Mr. Torres wanting to save his own life. And how dare he? How dare he not follow her script? What a piece of work this guy is.
Another one of these I'm 63. I can't imagine that. I can't imagine that. Her father's not around. I need to talk about the case a little bit. And if you'll remember, I'll get back to it. If you'll remember, lost my place a little bit.
Damn it, Margaret. It's here somewhere.
Let's start with the witnesses, and then I'll talk about sin. But the first witness out of the box for the state, if you remember, was Juan Torres, the brother. Remember that? It was some time ago. I know it's been a while. Y'all taking notes. You may have to go back. Their first witness was a good witness for us. Their first witness in their prosecution of Sarah Boone for murder was a good witness for us. Remember Tony Henderson did the cross-examine of Juan Torres. Asked him, what did you hear Sarah Boone say? Juan Torres, she was yelling, he's been choking me. He's been choking me. Mr. Henderson said, did that surprise you? Juan Torres said, no. That family knew what was going on. The police knew what was going on. The neighbors knew what was going on. Pearl Walker came in here, 80-something years old, in a wheelchair. Kevin Beck called her up. She saw it. Is there any doubt? Is there any doubt? I tell you why there's no doubt. In cross-examination, I got Dr. Warner to even admit. Did you hear it? Yes? Okay, Mr. Owens. She suffers from battered spouse syndrome.
So what? So what?
Wouldn't admit it on direct. Well, maybe. I don't really know. I hadn't had enough time to really see her. You hadn't seen the pictures? You hadn't seen the 2-minute video? You've seen her one time earlier this month. One time. And she's going to start testifying about stuff she's never said before until she showed up in court? About, well, based on what she told me, I don't think she was in imminent fear? Come on. This is a courtroom. This is a courtroom. Good thing y'all are here. We thank you. But it gets even worse than that. It gets even worse than that here in this courtroom. The state attorney referred to these pictures. And I was going to rise up and show these pictures to you.
Overruled. You may proceed.
That I was going to rise up and show these pictures to you. Well, yeah, I'm going to do that. They put her on trial for murder. But what did they say? And I got to turn to this, make sure I get this exactly like they said it. I took a bunch of notes. Let me make sure I got this quote. Can't even find it, but it was something to the effect, maybe George Torres is the battered spouse. Can you believe it?
Thank you, Mr. Owens, for putting the prosecution's argument in front of the jury. Maybe George Torres was the battered spouse. Uh-huh. And Mr. Owens asks, can you believe it? Yes. Yes, sir. Actually, I do.
Can you believe that? Now you know why we're here. Now you know why we're here. Little boys learn early on that girls are different. You do not put your hands on a girl. You can't wrestle with them. You can't punch them. You can't kick them. You can't treat women that way.
Don't go here. Don't go here. You know what, buddy? You can't put your hands on a boy either. You don't put your hands on another sentient being in a manner to harm them. You do not. It's not that little boys should be stoic and take crap from everybody because they're boys? What? So what? It's okay? But yeah, don't hurt the girl, but she can do whatever she wants to you. That is crap. He's a freaking dinosaur. No, he's an amoeba. He's not even as modern as a dinosaur. He's an amoeba. Owen's the amoeba.
When you become adults, I don't care what she does to you. I don't care what she says to you. If she gets in your face, whatever she does, you do not have a right to hit a woman. No, sir. What has the state attorney tried to do?
Objection, proper argument.
Sustained.
What have they done?
Objection.
What evidence have they tried to put on?
Overruled.
What evidence have they tried to paint Sarah as? What evidence? Controlled and manipulated were the words they used. You know, this ain't the 1900s. This is 2024.
This is 2024. Really? Somebody in the chat says, wow, we're getting such clear video from 1950. and then he says, oh, it's 2024. Dude, get with the program.
What's all these text messages? Why is that relevant? What are they trying to claim? She provoked his violence? She provoked his violence. Isn't that what they've done here in this trial?
Proper argument.
Sustained.
And we'll get back on this. Abraham Marino. I don't know if you remember him. Abraham Marino changed his statement. They took a statement from Abraham Marino in which Sarah stated, I don't know if you remember, but it was when the police were all there. I think they got the tape out, and some neighbors were coming around, and there were 2 or 3 neighbors sitting around. He said Sarah came out and stated it was an accident. Okay? Well, then, it was an accident.
That's not actually what he
Abraham
said.
Marino knew George Torres from Philly. Okay? They were friends. They would talk either at the complex, or if Marino went to Hall's Ace Hardware or Ace Hardware, what it was called.
This dirty pool right here.
The state attorney notifies.
Judge, I'm going to object to reading from things that are not in evidence.
Approach.
Yeah, he's misstating the witness testimony as well. Yes, yeah, it wasn't his testimony. You're right. Anita says he's running out of material, yeah. People in the chat are yelling, objection! I'm going to forward past the approach. Gaslighting the jury, somebody saying, yep. Yep. And it doesn't matter. It doesn't matter what she had. She didn't have the justification to do what she did at the time of the offense. Somebody in the chat thinks he's making the jury uncomfortable. Maybe. Andrea is saying he's straying too far away from that night. Yeah.
Marino said,
Sorry.
You may proceed.
There you go.
so for 4.5 years, Marino says, all I heard Sarah say that afternoon was it was an accident. Then he came in here today, or this week, and said, no, she said I was teaching him a lesson, things got out of hand, and then I fell asleep. 4.5 years later, we know he's friends with the Torres.
He's misstating that.
We heard it here. Now, I want to talk to you about the 2 boys that live right next door. You remember Vincent Battaglia and Brandon Motes. Remember those guys? And you remember it came out in the testimony, this event happened on February 23rd of 2020. But it came out in the testimony that Sarah had said, George Torres, the night before, February 22nd of 2020, grabbed me by my hair and pulled me down the stairs.
This is Sarah's gaslighting. And she's so practiced at it. And he's just repeating it. Look at the look. I just happened to pause here. Look at the look on his face. The look on his face to the jury is, please believe me. Please. Oh my God. I'm in trouble. I'm imagining the looks on their faces. So this is going to be more like, don't believe any of the witnesses except the ones we like. Don't believe anything except what we want you to believe. Hello, Sarah. Did she body snatch Owens and is now talking through him? Crikey.
In my apartment from top to bottom, which is consistent with what they were saying happened, remember? But they got their dates wrong. And remember, Mr. Henderson called Deputy Copsel, or Detective Copsel up in our case, and she had to say, yeah, I didn't take their two statements until the 27th. February the 27th, remember? So they're remembering back, and they both had similar stories. Of course, they had time to talk by then, the 27th. I think the only recorded interviews they got the night of this event, February 23rd, was from Sarah Boone and her ex-husband, Brian Boone, right? So they came back following up on the 27th. That's when they got a statement from Brandon Motes and Vincent Battaglia. And at that time, they said, yeah, we heard that sound. You remember Sarah testifying? No, that was the night before. I complained about that, and I think one of them had testified. Yes, she had said something about being drugged down the night before. It may have been, can't remember now who it was. One of them. And, you know, it looked like that there may be some implication that Sarah got him in the suitcase and pushed him down the stairs. But I think we didn't hear anything more of
that. Owens, you're brilliant. You're just a brilliant lawyer for the prosecution right here. If the jury had forgotten about that, Owens just reminded them.
Remember? And then this photograph, which we introduced, which shows the bottom of the stairs. As you can see, there's Lucas's bookshelf right here. This is where Sarah Boone stored Lucas's stuff. And you can see it's not disturbed at all.
Because she cleaned up. She had hours to clean up.
Anyway, I want to get back to Sarah. I want to talk a little bit about that. But let me talk a little bit about the law. Unjustifiable use of force is legal and lawful if you reasonably believe, I think we all probably already understand it by now, you reasonably believe it was necessary to prevent imminent threats of harm. The law is crucial, ensuring that individuals can safeguard themselves in potentially dangerous situations. By acknowledging you have a right to defend yourself when you have a reasonable belief that force is necessary to prevent an attack. Okay? What did Mr. Henderson say in jury selection? You don't have to wait. You do not have to wait. If you're facing, in your mind, a reasonable, imminent threat, you don't have to wait. Let's talk about Sarah Boone.
Imminent,
and this
reasonable.
Unconventional form of physical restraint to block the attack of George Torres. What did she say? You saw it. Now, you got to think about that. You got to think about what was going on. You got to think about the trauma she was undergoing. You got to think about they've both been drinking. And you got to think about the fact that it was all fun and games for a while. And I think the biggest thing to know is that George Torres chose to get in the suitcase. He's a grown man. That was his choice. She didn't force him in at gunpoint to get into that suitcase. He voluntarily got into that suitcase because they were drunk and being silly and stupid and playing hide and seek. Which I guess when you get so drunk, that seemed like a good thing. Zipped him up, they're laughing, carrying on. And as you know, Sarah likes to videotape a lot. And I know you've seen...
Yeah. She likes to videotape things that could hurt Mr. Torres. She likes to videotape for ammunition. So why did she not videotape him threatening her? Why?
Some of these videos and you're wondering why, but I think the evidence shows that when George is being videotaped, he's not going to do anything. If you think about that. When George is being videotaped, that's like her power. You know, Dr. Harper said that Sarah's words are her power. Sarah's words are her power.
No, that's not what was said. That was what the defense attorney asked the doctor.
Physically, she's no match for George. Physically, she's no match. But that's her power, in other words. When she gets a chance, to have some control, that's what she does. And she videotapes because she knows when she's videotaping, she can tell it like it is. I can tell him what I want to tell him. A couple of these videos you've seen where she's telling him like it is. But she's got that video camera on, and George knows he's being videoed. We've got one that we're going to show you in a little bit, where he loses it just a little bit, right at the end. And then, of course, we got the TV. But they're kidding around, playing around. Then, Sarah realizes, okay, this is my chance to say something to him. So she sits down, she turns on the phone, and you've seen the tape. You've seen the tape. For everything you've done to me, are the first words out of Sarah's mouth when the video begins. There's a lot packed into those words. Think about that. For everything you've done to me.
Yes, there's a lot packed into those words. And I'm sure Mr. Owens is going to tell the jury that this is an indication that he'd been mean to her before. But guess what? She was so angry with Mr. Torres for not listening to her enough, for brushing her off in the car. That would be included in the "for everything you've ever done to me." He drank alcohol that she could have shared in, and that was bad. He was sleeping in the hall on the floor, and that was something she was doing to him. She woke him up to say, "You're bothering me." He was asleep. So everything you've ever done to me doesn't necessarily mean that he'd done anything to her that anybody else would consider something bad, right? And do you know what else those words are packed with? Venom. They're packed with venom. They're packed with hatred. They're packed with intent of revenge.
This is how it feels when you choke me. Now that's in direct response and the result of the abuse that she has suffered at the hands of George Torres. She wants him, for that moment, to feel how she feels. She wants, for that moment, to feel, for him to feel how she feels. How uncomfortable, lack of control that she feels when George is violent with her. Just for a moment, she wanted to be able to feel that. And if you can imagine,
Approach.
Just going to fast forward a minute.
she was crazy about that. And I don't know if, of course it's a syndrome, but she felt like she couldn't do without it. And let's say she videotapes him, and then it's turned off. And there's a 9-minute gap, 11-minute gap, whatever it is. I said 11, they're saying 9, but I think if you count 2 of the other, then it's 9. But there's 9 minutes that we don't have video. But what did Sarah say? Now, if you remember when you listen on that video, George is talking in a normal voice. He's not stressed. Of course, if you're talking, you can breathe. She had said she had some air. And of course, she doesn't realize the situation, that it's going to end the way it ends. So she has no appreciation of that. It's a canvas. All she knows is an old canvas suitcase that she's got some, the 2 zippers removed, or spread out a little bit. So
If they look at that video, they're going to see that the 2 zippers are not spread out. And besides that, it doesn't matter, to a degree anyway, what Sarah thought about whether or not that was likely to end in his demise or serious bodily harm. The standard, the test, is a reasonable person. So it doesn't pass the reasonable person test, right? Not to mention that he actually told her he couldn't breathe. And I mean, a child knows if somebody can't breathe that that's a problem, right?
So she thinks he's not being serious. But eventually he gets angry. She gets angry, he gets angry. He says words to her, and then his hand starts to come out of the suitcase. She also said his tone changed. And I know everybody's got a cadence with their spouse or boyfriend, girlfriend, but you know what I'm talking about. We've got a way of talking to people. We've got a way, your wife, your husband. You know each other. You know when they come in from work, what kind of mood they're in. Just by a couple of things, the way you just sense it, right? Well, especially somebody as hypervigilant as Sarah and as hypervigilant as a battered spouse woman would realize that he can flip the switch at any time. When I get out of here, I'm going to end you. And he realizes he's getting out. He got his hand out. At that moment in time, in Sarah's mind, that's an imminent threat. So she's got a justifiable right to use force. What did she do? She went over there and grabbed it. She lifted it up. She tried to get his hand back in, remember? She tried to get his hand to go back in. Wouldn't go back in, so her son's back was 3 feet away. Where the police found it the next morning. Same spot. No attempts to hide. No attempts to delete the phone. No attempts to tamper with evidence. Nothing. In the same spot as it was. She picks up the bat. She pokes. She pokes him hard. Trying to get him to stop trying to get out. And eventually he does. And you've seen the blunt force injuries. And you saw some of the circular injuries where you can tell there's a poking. I think it's right around here. And she poked him several times. You remember the pathologist said, I think, maybe 5, 6, or 7 times.
Oh, he is purposely conflating something. He asked the pathologist if the injuries proved that it was poking rather than a strike, and she wouldn't agree with that. She wouldn't say that. So it's Owens himself in closing saying poking. Then he brings up the pathologist so that the jury could have the mistaken belief or even a mistaken memory now that the pathologist actually agrees with that. Not that any of it matters because Sarah's full of crap.
She pokes him. And he's got some scratches. I don't know if they'll let you look at it, but on the back of that suitcase, it's got some bars, some metal bars that are inside the lining. There's some lining, and it's for support when you walk it around. She testified. You heard what she said, that she was justified. That's uncontroverted testimony. Now, let's talk about the jury instructions just for a minute. And, I want to talk about reasonable doubt for a minute. Can't find the page, but I've got a book. I've got a book here. If we find it. If y'all are all looking.
Damn it, Margaret.
I think it's on page 15 or 22. And we're going to talk about reasonable doubt in a minute, but if you look at those bottom three short paragraphs, it is the evidence introduced in this trial and it alone that you're to look for the evidence or look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence itself, a conflict in the evidence, or lack of evidence. But here's the main thing. And, obviously, I represent her, and I'm trying my best to show you honestly and fairly the doubt in this case. And 5 reasonable doubts, 17 reasonable doubts, 25 reasonable doubts. You have to have 1 reasonable doubt. I'm trying to show you throughout the evidence that each one of you can have a different reasonable doubt. Difference, but 1 reasonable doubt about the state's case, and your verdict is not guilty, according to law. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, speculative doubt, or imaginary or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. And this is a deeply held belief. Reasonable doubt is the highest standard we recognize in litigation. Car wreck or something like that is preponderance of the evidence standard, 51% you're entitled. Abiding conviction, that's a deeply held belief that you must have if you're thinking about something. That's a firm belief. That's a
The only
level
thing
of
worse would
certainty
be if he was using a
that you would have.
chalkboard.
That's what you got to have as a juror. I've got to be certain of her guilt. If, on the other hand, if after carefully considering, comparing, and weighing all the evidence, which we want you to do, there is not an abiding conviction of guilt, so I'm not certain. I'm not certain of her guilt. Or if you have a conviction, I think there's some evidence of guilt, but it is one that is not stable, one which wavers and vacillates. One
Like the
which
defense?
wavers and vacillates. Then the charge is not proved beyond a reasonable doubt, and you should find the defendant not guilty because the doubt is reasonable. You understand that? You've got to be certain of guilt. That's the highest standard we recognize. If I've got some evidence of
Can they find Owens guilty too? Good Lord.
guilt, so okay, there's some evidence for conviction, but it's not it's not stable. It wavers and vacillates. Then under our system, you've got a reasonable doubt. And you've got the power and authority and the obligation under the law, if that's the way you feel, to vote that way. Later in the instruction it goes on, it's up to you to decide what evidence is reliable. You should
Here's
use your
another
common
one.
sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You may rely on your own conclusion about the credibility of a witness. That is totally the province of the jurors to decide that. A juror may believe or disbelieve any or all the part of the evidence or the testimony of any witness. Dr. Warner said, this is their expert again, who testified that Sarah Boone suffers from battered stop syndrome. Battered women's experiences affect her perception of imminent danger. Those past experiences with George Torres, and there's a bunch, affect their perception. Remember Dr. Brandon?
That's not the test. That's not the test, Owens. Now the prosecution is going to have to, that's not the test.
Michael Brandon talked about perception of imminent danger. Victims of repeat violence may fear death in situations others would not. The reason Sarah experiences all this, the reason she was feeling the way she was feeling, that imminent threat of danger from George, was because of George Torres. George Torres is responsible for her mental state because of the way he has violently treated her. She reacted to his attempts to get out because of the way he treated her and the way she knows what is he going to do if he gets out of the suitcase. She knows. The second video is played. She's flipped it back upside right. You hear him, it's 22 seconds. He says, Sarah, she's not going to open that suitcase. She's not going to open that suitcase. He's already threatened her. She used the bat to get him to stop trying to get out of it.
The test is an objective
Why
one,
would she
not
do
a
that?
subjective one.
Why would she do that? I know what he's going to do. I know what he's going to do to me. I know him like I know him more than he knows himself. I know what he's going to do to me. You don't have to wait. That was justifiable. Now, you got to understand this. She intentionally used the bat to defend herself. She intentionally didn't unzip him to defend herself. Both of those are lawful.
And she intentionally didn't call 911, and she intentionally walked up the stairs and went to bed. Oh, and by the way, before she went to bed, she intentionally made a phone call. She intentionally lied. Okay, the jury can't be this stupid, right? Reassure me, they can't be this dumb.
Under our law. She went upstairs. The dogs were upstairs. At some point, she called her husband, her ex-husband, Brian Boone. We know that many times she testified, or somebody in court said she would often flee to her ex-husband's house sometimes. I believe that testimony came out from either Sarah or somebody. That sometimes she would flee, or sometimes she would flee to upstairs. One of those two. But the dogs were up there. She made a phone call. At some point, she fell asleep. Passed out, fell asleep. We don't know. They had 2 big bottles of wine. Right? That was unintentional. That was unintentional. His death was unintentional. You remember when she was in the interrogation room? You remember that? Now, I don't know if we did a good job of this, but it came out that she got arrested. You remember the one time when she got the black eye? She got arrested for strangulation. And you remember that? They ended up over there by the dryer, and he was banging her back of her head on the floor that had very little.
No, that's what she said. That's what she said.
Carpet on it, and she ended up getting her arms out, and then she grabbed his neck. And she eventually got him off of her, and that's when he got up and stomped her in the eye. Remember?
But they were two different incidents. When she got arrested for that, it was on the stairs.
Well, the police came for that event, and they took statement, and Sarah was honest with the officers about what all, and they arrested her. You remember? Remember that? They arrested her. And she said, why? I was fighting back. You remember that? Why? I was fighting back. So from that point on, she didn't trust law enforcement. The video that they showed a while ago about George, that was about dropping the case, where she was defending herself and fighting back. I want to talk about this investigation by law enforcement.
Oh, God, stop, Di. I want to talk about it. Shut up.
She didn't know the law. She's not a lawyer. She gets up the next morning. Brian's calling. Sarah's got to pick up Lucas at 3. Brian's calling. Eventually she walks down. She's looking for George. Where's George? He's quiet down there. Then she looks in the bathroom. She looks out. He's smoking a cigarette. Is he on the computer? She sees the suitcase. And you can imagine.
Objection, golden rule.
Sustained.
She sees him in the suitcase. She panics. What does she do? What does she do? She tries to get her fiancé out of the suitcase. They're engaged to be married. She's not trying to kill him. They're engaged to be married. She gets him out. She tries to do, he's purple. She tries her best to do CPR. She doesn't, you heard her, I didn't know what to do. I didn't know, call Brian. That's her safety valve. That's all she's got. Brian eventually says she's come over. She calls again in 2 minutes. I'm on the way. He gets there. You got to call 911. They have told her before. Call 911. She calls 911. She tries to do CPR again. Is she busy trying to hide evidence? She busy trying to hide evidence? She busy trying to hide the back? No. She's trying to save his life. If she can.
Because she was up all night fixing the scene up.
So the police get there. She knows if she told them she fought back, she's going to be arrested. That's what happened before. That's what happened before. Like George has said on the video, she'd never been arrested before. Before that time, she was charged with that with George. She lies. She lies. She's scared. She's scared. She doesn't know what to do. So she lies. She makes a decision to lie. Don't trust law enforcement. She doesn't know the law. She doesn't call a lawyer. She talked to Officer Rodriguez, was the first short black female that came up here first, the first one that arrived with body cam. Talks to her. There's a recorded statement there where she doesn't tell the whole story. She lies. And then the detectives eventually get there and get her in the squad car. You hear the audio. I think it was played. She lies again. Then the next day, she goes down to the sheriff's department. Now, if they would have told her, hey, ma'am, we're going to arrest you. And she gets a lawyer to go down there to make a statement. And the lawyer would advise her.
Objection, facts not in evidence.
Sustained.
Move to strike.
Stricken. The jury will pay no mention or give any weight to that statement.
not a lawyer.
I just want to
She
talk
didn't have a
over
lawyer
him.
present when she made this statement. She didn't know the law. She didn't know she was justified
Yeah, no, she wasn't justified.
in defending herself.
She didn't
What
defend
did
herself.
in this dysfunctional, toxic, abusive relationship.
And she did know the law well enough to weaponize it against her victim. Okay, we need Owen's jokes, seriously. Oh, okay, you guys are saying don't pause him, just talk over him? Okay, I will.
I don't know if you remember, it was a 2-hour video, but there was some things she said, it was not intentional. And eventually, she wanted the detective, it was Detective Lowen, the male detective. And she said, I swear to you on my son's life, it was not intentional. What she was talking about was that George passed, was that George died. That was not intentional.
I could see that part, but that's not the test.
She thought he was fine in there. Would he sober up? We've learned from their history, when Sarah gets drunk, she calls for help. When George gets drunk, he beats Sarah. That's their pattern. How many times did we see Sarah call on the law? That's their pattern. Sarah told him, I didn't know, I think she said, I didn't know something like this could happen. I've never done it before. And Detective Lowen said, well, what did you expect was going to happen? And I've got a daughter that she was about 18 or 19, and she got a grandmother's hand-me-down.
And now we're going to talk about Owen's daughter. Because when Lowen
She didn't have
said,
it
what
long,
did you
and,
expect?
she was gassing it up, but she didn't put any oil in it. Eventually,
Didn't
it
she
burnt them
say, I thought he was
And
going to come upstairs for
up. You don't know
relations?
what you don't know. I hadn't done a good job of explaining, hey, you got to put oil in it too. Sarah Boone didn't know that he could die in there.
Hi, I can't
It's
breathe.
an old beat-up canvas
You could
suitcase
die. You can't
that she
breathe?
left
That's a
gap
pretty
in
good
it.
indicator. Reasonable
And
person.
as naive as that sounds, she didn't appreciate the danger.
She didn't give a
Is
rip
that
about
way
the
you wanna
danger.
kiss
That's
him?
what.
Is that the way you're going to do it? She had Lucas to take care of. Am I going to go to prison doing
She
it
never
like
took
this?
care of Lucas.
No attempt to hide the crime.
She didn't have a choice. She couldn't pick him up and carry him and throw him in the pond. That's
That's how
why.
this happened.
Because Brian told her to call 911. Because Brian wouldn't help her hide the crime.
I don't
That's
know
why.
I do want to show you. Just quickly show you the injuries. Sarah Boone got stabbed.
And we don't know the circumstances around that. We just have this
Stabbed with a
bizarre
steak knife
story.
in the leg. And she stayed with him. She stayed with him. Poked between the eyes with a curtain rod. Stalked in the eye.
And this is not the test. It doesn't,
And who does that?
it matters, but not for this crime. It's not a defense. Revenge is not a defense. Doesn't matter. Yeah, somebody's pointing out, get stabbed, great passive language there. Exactly. Yeah, somebody's saying she didn't stay with him, she stalked him. Yeah.
The law empowers
He
an
tried to
individual
leave.
to defend their life and safety when faced with a threat and to prevent an attack.
Yeah,
That's what
because you're
Sarah Boone
allowed to
did.
try and get out of a suitcase. You're allowed to breathe.
That's what Sarah Boone did.
Yep, dead men can't testify. Someone in the chat saying. Everybody's asking, how much longer has he got? Oh, we have to be tortured for so long. Oh, is this another damn it, Margaret moment? Oh, Shmita thought for a moment it was over. No, no, no. You're going to be tortured just a little bit longer.
I think it's important to understand Sarah had to be the parent a lot of times. It was her place. She had that $1,000 a month from the divorce settlement coming in.
Should it be the parent?
She had the car. She had the phone.
How demeaning.
She had the keys. She had to be the parent in a lot of ways.
How demeaning. That's part of the problem.
I want to talk a little bit about Dr. Harper. If you remember,
We were talking about Dr. Harper.
is from Okaloosa County, which is up in the Panhandle, close to where we're from. And she's the doctor that treated Sarah from early on. Remember, this happened in 2020. I think she first treated or first saw Sarah Boone shortly thereafter. And over the 4.5 years, saw her 9 times and did all the testing for post-traumatic stress. Of course, she has the experience from the veterans, and she's testified that she's now just traveling around the state, testifying as a forensic psychologist. But you know, she talked about how important it was to develop trust with the patient over a course of time. It's just going to take time when you have somebody suffering that kind of trauma.
Sarah wasn't
that kind of
her
damaged
patient.
psyche. It's going to take some time.
Assessment and
get there.
treatment are different
Where they can
things.
trust you and really tell you and talk to you and tell you what's going on with you.
Yeah, yeah, yeah.
You know, she talked about, you know, that Sarah uses her words for power. I think her testimony, I don't think, but I think the evidence supports that her testimony was credible.
Objection.
The evidence supports that her testimony was
Objection
credible.
is sustained.
I can't give my personal opinion. Okay?
There was
The
an
evidence-
objection and he kept
The
going.
evidence supports that her testimony was credible because of the time that she.
Oh, sorry. I'm not going to
because
pause.
of the
I'm talking over him.
tests that she did.
He just talked
She's
over the
diagnosed
judge
with post-traumatic
sustaining the
stress
objection.
disorder, alcohol use disorder, I think anxiety disorder, and battered spouse syndrome. Of course, Dr. Warner confirmed that, and you know, Dr. Michael Brannon, the first witness, he was brought in as a subject matter expert, so he hadn't treated Sarah. He was just testifying about the condition. He's been doing it a long
He's
time.
minimizing his
That's
own expert.
And that's to advise you to try to understand what's going on. And as crazy as it sounds, in this syndrome, they try to protect the abuser. They're in love with them. They try to protect them. I don't know if you remember that there was a time
Like Mr. Torres did.
Sarah Boone had a conversation with one of the neighbors, and they were talking about something. And she said, "Did you hear anything yet last night?" Remember, she said, "Shh, it's okay." Both George and Sarah lied to the police. They lied to medical people. I don't know if it's shame, but it just comes with the syndrome that you stay trapped in it. When Sarah gets beaten by George, she calls the police. When Sarah gets beaten by George, she calls the police. And a lot of times she just wants him out. Just get him out. Get him to leave. She doesn't want him to get in trouble. She just wants him out. There never was a report of George calling the police on Sarah.
No, because he looked at the officer and said, if I called you, would you have come?
The state is trying to present evidence that she emotionally abused him.
Sustained.
Move strike.
Stricken. Members of the jury will pay no attention to that comment. Give it no weight whatsoever.
I believe the evidence that's been presented by the state is an attempt to show that Sarah mentally or emotionally abused George Torres. Again, she's not charged with that. She's not perfect. Some of that was her trauma.
And he's not charged with doing it to her.
In Sarah's situation,
She's charged
you
with
become
murder.
and hardened.
If we want to go by, what the charges are, that's the argument you want to make, Owens.
It's a day-to-day thing, some good days, some,
You opened the door, bud.
But the homicide detectives, I know if you saw that 2-hour video, at some point during the 2-hour video, they started talking about some of the violence. And they go, we know. We know. They had already checked with neighbors or whoever. They knew. The neighbors knew. Police officers knew who responded. Torres' family knew. They all knew about the abuse. Dr. Harper testified that abused women act differently when they perceive a threat. I think Sarah Boone was loyal to a fault to George, even through all the abuse.
Loyal? That's why she ripped up his birth certificate? That's why she trashed his family? That's why she weaponized the system? That's loyal? Wow.
Judge,
Wow.
I want to make a comment about a couple of things that were said by the prosecutor in opening statement.
You can't.
Proceed.
Okay.
Really?
The prosecutor in opening statement, when he was talking about George Torres passing away, and started talking about Sarah Boone, and his quote was, because I wrote it down, George, in Sarah Boone's mind, George Torres deserved it.
She said, for everything
George
you did to me.
Torres deserved it. That's the position they're taking.
She said, for everything you did to me.
He deserved to die. She loved the man. She wasn't trying to kill him.
No, she just didn't care if he
He
died.
also commented about
Judge, may I move the motion?
Yes.
So, so now okay, Owens is putting the state on trial now. So Mr. Jay's on trial for what? For commenting? Come on. I'm gonna fast forward. I hope she's crapping her pants right now. I'm so irritated. And she even said, yeah, I wanted to make him squirm. She said she wanted to make him uncomfortable. She wanted to, even the defense concedes that she wanted to. So glad. I just want to look at his family. Mama Torres isn't there. It's so sad. She probably couldn't handle it anymore. Come on, fast forward. I wonder what Looney Boons is thinking.
said in opening.
Whoops.
The prosecutor said in opening about the violence, the violent episodes. It's a bunch of violent nonsense, was his statement to you in opening statement. All this here, the photographs, is a bunch of violent nonsense. You'll have to make your mind up whether that's accurate. There were a couple of exhibits that I introduced late, and they were no contact provisions, where there had been a court order from a judge, not only a verbal order, but it was reduced to writing. So there was a court order for George Torres not to have any contact with Sarah Boone. Okay? Court system got involved. They would have no contact with George Torres. Now,
They also
talk a
have
little
the
bit
text
about that.
from Sarah saying, come
And they
back.
talked about coercion, coercive control, power and control, power and control. We know about his abuse. We know he destroyed the home, the TV. We know about his jealousy. We know some of the things he said to her. We know about how he treated her dogs nicely when he was sober.
You
But
lie.
at times, he abused the dogs.
Jealousy is
Or
not
threatened
the
to do
issue. It's irrational jealousy that's the issue. If your spouse is sleeping around, then it's pretty reasonable to get jealous. It's the irrational jealousy that becomes a problem.
If you think about power and control, when you're controlling a person, and I think she testified that he kind of smothered her, was always around her. Part of his fear was her realizing that she'd had enough and to leave him for good. That she would get the strength over time
People are wanting me to fast
if she had enough time
forward.
away from him.
I'm concerned that some
Or
people
she wasn't in control of it, and he
don't
wasn't in
want that,
control
though,
of
that you want to hear it.
it.
So
Enough
I'm
time
going to
away,
need more people to tell me what you want.
she would come to her senses and realize she could do better. The judge has been giving court orders all week. I didn't stop George Torres. George Torres knew he was going to lose control if she had a bunch of time away from him. She might move on. He was willing to violate a court order to maintain control. That's George Torres. I want to show a couple of videos. And I want to say something to you. Shelby Andrews is going to help me. If we could dim the lights.
Yes.
Oh, Margaret, why didn't you keep him at home?
Do you understand?
What do you mean?
As of this moment, and until I can get you out, get the fuck
Fuck out of here.
You're a room. Get the. I dare you.
Did you see him
Yep,
flip
look,
the switch?
look at him. Look, get away from me.
Fucking.
Get away from me. Get away from me. I'm gonna scream bloody murder. I'm gonna scream bloody murder.
Did you see him flip the switch? In that instance? Where he lost it? Even though the video was going. Show the next one. Thank you. Thank you, Judge. You turn it off. Can you turn it off? Ladies and gentlemen, I'm going to finish up right here. And Sarah Boone, I've gotten to know.
Objection. Proper argument.
Sustained.
Sarah Boone is like any other citizen. Equal justice under the law. She's to be treated like any other citizen.
Yeah. Lock her up.
Fairly and impartially.
Convict her. The evidence
Based
is
on
clear.
the circumstances she was facing at the time of this tragedy. Based on the battered spouse instruction, which is a special instruction that's given when women have a heightened sense of fear
People.
and trauma
Battered people.
that you're to utilize in applying her subjective standard to the reasonable standard of what a reasonable person would do under her circumstances in using the force that she used to defend herself. I hope I hadn't missed anything. I've tried my best. Sarah Boone fought back and survived. We ask that you do justice in this case and find her not guilty because the doubt is reasonable.
No, it
I've
isn't.
tried to
It's revenge.
show you where
Depraved
the
heart.
doubt was. I trust your judgment. We spent a long time picking the jury, 4 days. We trust you.
No, you don't trust their
We
judgment.
appreciate your service.
If you trusted their judgment, you wouldn't
obligation
have
to
to
do your duty.
gaslight them.
You have the power and authority to right this wrong. That's what we're asking you to do. And give Sarah Boone some hope for a better life and freedom.
God help anybody who has to be around her
Thank you,
then.
sir.
He doesn't trust
Any
their
rebuttal?
judgment. You just tell the
You may
truth
proceed.
then. Let them judge. Tell the truth. Oh, we're not going to hear from Henderson. Beautiful. Yeah, okay, let's hear this. Come on, Mr. J. Okay, I'm going to mute myself because I don't want to talk over Mr. J.
Ladies and gentlemen, George Torres is dead because the defendant believed he deserved to be zipped shut in a suitcase so that she could make him feel how she felt when he cheated on her, when he choked her, and to hold him there as a captive audience, according to her testimony. Now he has to listen to me. Well, right out of the gate, there are credibility issues. Cheating to me means viewing pornography. Well, we saw cheating really means women. And the heated conversation on June 14th about these women in Facebook. And that is what leads to the arrest on June 15th. He's out whoring, Candy Crush, all the bizarre things that you see in her phone. She uses the legal system as a weapon at times. There's no denying that they are engaging in violent behavior, and it is over nonsense. It is smashing TVs. They call the police, and then they're standing there looking bewildered about what to do and who to say, and laughing and joking. Ladies and gentlemen, the courtroom is the place for justice, not a suitcase. The reason we have a jury system originally started with the idea that the king, the crown in England, shouldn't be able to go and incarcerate citizens on his whim. So it developed into a system where citizens would have to say, yes, you can take our fellow citizen. But the opposite is also true. A citizen cannot take another citizen's life because he or she feels like it. That likewise requires a jury to decide that it was objectively reasonable for a person of ordinary prudence and caution. Like Mr. Cacciatore argued earlier, battered spouse syndrome is not a license to kill. Past grievances, even being stabbed in the leg, so on and so forth, do not give her the license to kill. There are still laws in place about when and how this can be done in a justifiable manner. I want to talk about the most important jury instruction in this case that has not been discussed very well or thoroughly. Excuse me. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself. And we'll stop at that comment. The facts of the case that came from her own mouth, if she is to be believed, and we will explore thoroughly why you should disregard every bit of her testimony, from court to the detectives, to the 911 operator, to the doctors. Her testimony, if it is to be believed, the most favorable light that she has presented of herself, is that at the end of a Sunday fun day, where we are drinking, we're outside by the dartboard, we're doing puzzles, we're doing arts and crafts, and there finally comes a point in time where we're going to play hide and seek. And he says, "Tag, you're it." Even though she's it, she goes upstairs, hides in the shower, eventually gets tired of being there, it's cold, so on and so forth, and she comes back downstairs. And as she comes back downstairs, she can see Mr. Torres fiddling to place himself inside the suitcase to try and hide for this game. And the lid is not closed and it's flapping. And out of jest, out of levity, undisputed according to her testimony, she comes over there and zips it shut. Whether it's 100% or enough for 2 fingers to get out, that is something that you decide as the jury. But there came a point in time where the fun and games was over. And Mr. Torres told her that. "Babe, I can't breathe. Sarah, babe, let me out. This is all on video. We don't have to imagine this. This is all on video. 1062. At that point in time, she is using force against him that is not justified. She is the initial provocateur. She is the aggressor under the law. And what level of force is it? I can't breathe. Not let go of my hand, not get your hands off me. I can't breathe. This is no different than 2 people, maybe they're buddies at the bar, similar to an example that was given by Mr. Owen, who are wrestling, and one has another one in a headlock. And there comes a point in time where the person on the receiving end of the headlock says, that's enough, I'm tapping. George Torres was tapping. And she ignored it. And she was kind enough to tell you why. Out of anger. Which translates to hatred, ill will, spite. Just like that in jury instruction for second-degree murder. She told you exactly why. She got angry. Him saying, "I can't breathe, babe," was what triggered her. Not a fear of imminent harm. Those are her own words. That is the law. These are the 2 paragraphs that solve this equation without getting up on a big whiteboard in college that's 30 feet long, 15 feet high, and a ladder, and somebody's scribbling Latin words and Greek letters for months and months to solve this huge, complicated equation. The equation is solved in 2 paragraphs. She is the initial aggressor. He is saying, "I can't breathe," It is no different than a naked chokehold that she does not let go of. And she told you it's because I want him to listen to me. This is my bully pulpit. This is how he made me feel in the past. She doesn't describe it as teaching him a lesson, but that's exactly what she says. I want him to feel like I felt in the past. I want to tell him things. Ladies and gentlemen, we can play semantical games, but that is teaching him a lesson. Therefore, we have to look at the other two paragraphs. Because right now, plain as day, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threat and use of force against herself. And what force are we talking about? Well, the threat of force that she tells you she was facing was him fighting for survival. Him sticking his fingers out of the suitcase. Him sticking his hand out. That is the threat of force, coupled with, I'm going to end you. Well, ladies and gentlemen, she is the initial provocateur. She is the one using deadly force against him. If I have somebody in a rear naked chokehold, they are entitled to use deadly force against me to break that chokehold, at least until we're separated. He had every right to say what he said. He had every right to exist and stick his hand out and try and survive to breathe another day. However, the use of force is not justified if you find that Sarah Boone used the force to initially provoke the threatened use of force against herself, unless she does one of two things. And she did neither. Not even close. The threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm. All right, let's give her absolutely every benefit of the doubt, which you should. This is a criminal prosecution. The state of Florida has alleged she committed murder. You need to do everything you can to look for reasonable doubt. But a reasonable doubt is not an imaginary doubt, a forced doubt, speculative doubt. So accepting that all of their past history, accepting the doctor's testimony, and the limitations on what they reviewed compared to what we reviewed. We did a much more thorough review of the relationship than any of the doctors did in this case. So let's give her that first clause. Because of their past relationship, with George now fighting for his right to exist and saying that he will end her if he gets out, we'll give her that. But just like Mr. Cacciatore mentioned earlier, lawyers' words mean things to us, and they mean things to everybody, but really to us. Or an and. There's an and. Had exhausted every reasonable means to escape the danger other than using deadly force on George Torres. She did not use every reasonable means to escape the danger that now, after provoking him, that he was presenting to her, according to her. She didn't pick up her cell phone and start walking. Call 911. She didn't do anything other than, if you believe that is why she called Brian Boone, made a phone call to Brian Boone, and unfortunately because of past history, he just ignored her drunken phone call. She did not exhaust every reasonable means to escape this danger that she created. She started it. She created this. Other than using the deadly force on George Torres. Now, this is a weird situation. This is not a rear naked chokehold. This is a suitcase, or as Mr. Cacciatore said, a box, or actually more aptly described it as a coffin. And when you secure somebody into a box or a coffin, you can still exert that deadly force on them from a distance. I'll give you a quick example from a couple of movies that I love. In 1977 in May, a movie came out. It's called Star Wars. They eventually called it Episode 4. In the first scene, there is this large, imposing figure that wears black armor. He is a government agent, and he is looking for some stolen classified documents. He picks a man up who he believes is responsible for this treachery and breaks his neck and chokes him to death when he doesn't tell him where the plans are. We all understand that. That is direct force we all understand. But what we need to understand is the force she's exerting from the couch. And then when she goes up to bed, she is still exerting that force on him. She set these implementations into motion and did not stop. So later in this movie that came out in 1977, another co-employee of this dark, imposing figure, Vader, insults his religion. He does not go to HR. He takes matters into his own hands and chokes this person
Darth Vader doesn't go to HR. That's great.
from a distance. Ironically, while we're talking about force, it's the force. And then in the subsequent movie, he's like doing it from his office. He's killing his incompetent employees on different ships. Force, deadly force, can be exerted from a distance in this situation. So whether she's on the couch or whether she turns in for bed, she is still using that deadly force on him. She has not exhausted every reasonable means to escape this danger. Do something. You started this. You put him in the position where he cannot breathe. She's required by the law to do something about it. Not something, everything. There was no efforts in this case. None. Or, in good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force. But George Torres continued or resumed the threatened use of force. That did not happen. She never withdrew from physical contact. She is still, like Vader, choking him from the couch, choking him from bed. She never withdrew that force. Physical contact includes any restraint on George Torres' movement. She never indicated that she wanted to withdraw. Sarah, babe, I can't breathe. All right, if I let you out, are you going to come out peacefully? Since I started this, I'm the one that made you not be able to breathe. That didn't happen. So, ladies and gentlemen, this entire analysis about deadly force starts and ends there. She was the provocateur. These are her obligations when she starts it. She put him in fear of death. He is literally telling her, I cannot breathe. A couple other things about the law. Second-degree murder does not require a proof of intent to kill. Argument was made repeatedly that she didn't intend to kill him. That has never been the state's suggestion. Because why would we suggest we prove something that we don't have to? It's not her subjective belief. Well, Sarah Boone doesn't believe that this suitcase can kill him, even though he's repeatedly said, I can't breathe. It's a person of ordinary judgment who would know is reasonably certain to kill or do serious bodily injury to another. A person of ordinary judgment who hears, I can't breathe, babe, Sarah, and his voice gets weaker 9 minutes later, you're on notice. This is statutory notice. Done from ill will, hatred, spite, or evil intent. Her words speak for herself. This was not out of fear. This was out of hatred and anger. Born out of all those horrible things that has been done to her and done to him. Understand it. We're not going to belabor the past. Is of such neighborhood that the act itself indicates an indifference to human life. I don't care that you're saying you can't breathe. Fuck you. That's my name. Don't wear it out. Fuck you. It's second-degree murder. We do not have to prove the intent to kill. We have to... She intended the act. She intended the act of zipping him shut. She continued to intend that act when he said, I can't breathe. That act resulted in his death. That's a manslaughter, but then when you add in the hatred, ill will, spite, and the depraved mind, that's what makes it second-degree murder. And that 2-minute video is the textbook definition of depraved mind as we define it here in Florida. Voluntary intoxication is not a defense. You cannot feel sorry for her because they had 2 1.5-liter bottles of wine and then some from the leftovers from the day before. And quite frankly, she's blackout drunk. She's blackout drunk. She doesn't remember making the videos. She turns her phone over right to the deputy the next day because she doesn't know what's on it. She doesn't remember doing it. Another thing that we just haven't talked about much is her story. She can't be up in the shower hiding and taking a picture at 11:03 p.m., 9 minutes before the video. That portion of her story just doesn't add up. And what it shows is it's more like 20 minutes instead of 11 or 12 minutes that we know he's trapped in what turns out to be his coffin. Let's talk about her testimony at trial. And we'll talk about all the problems. A lot of her issues predated her relationship with Mr. Torres. So it's not attributable to the trauma from Mr. Torres with all the luggage she brought into the relationship. And listen to the way she talks. It's not splitting the bills. It's helping without argument. It's not cleaning up and doing Sunday chores. It's cleaning up so we can relax. It's a reward. She talks about him like he's a child. I need to lead him to the next activity from one to the other. And then you saw the videos, and I'm not going to belabor it, that we showed in rebuttal, but the relationship and the power dynamics speak for itself. He was treated like the third dog. And it might very well have been a dog that bit and was violent, but he was treated like a dog. Why are you leaning against my door? Get out of here. Go downstairs. You're worthless. You're garbage. They showed the part of the video where he slaps the phone, but that's after 5 or 6 minutes of being berated and dehumanized in a way that nobody should be treated. He just wanted to get in bed and lay down next to his fiancée. Instead, get away from the side of my door, you useless dog. I thought it might be a good point in time to listen to the music. You know, when does Mr. Torres get to decide what to do? I mean, she paints this picture that he goes off and does all these things on his own, goes and buys wine when he's not supposed to, does all these things when he's not supposed to, but when does he get to do what he wants? Suitcase downstairs for a week so they can donate it. What was in their lives that was preventing them from getting that suitcase to the Goodwill or whatever? Neither one of them worked. What's going on? Lucas is over there on Mondays and Tuesdays. The story about the suitcase having already been down there is quite suspect, and we will get into that more. But again, it's not we went on a trip together, we had a great time. It's, I quote unquote, I recently took him on a trip. Then it comes down to the moment of truth, which we've already gone over. And it's just quite frankly inconsistent because she doesn't, there's no explanation for the picture. Her explanation at trial when I brought it up to her was, I just don't remember. I don't remember this period in time from the picture at 11:03 to when I was supposed to be coming down the stairs. There's a major glitch in her matrix. She shakes the suitcase. Please stop doing this to me. And then his hand gets out. Now she's the point in time where she gets angry and doesn't do what the law requires after basically choking him with his coffin. Beats him into submission with the bat and turns it back over. For the first time ever at trial, she says, I'm going to fucking end you, is what he said. She never told that to even her doctors. We've heard the arguments why she didn't tell the truth to the police and all that. And there's a lot of truth into the argument that was made. There's a lot of truth. When the argument is made that she didn't understand self-defense, what that means, what it comes across as, she makes this story change as she learns about it. When we apply the jury instructions to her statement, all 6 of them apply against her. Won't belabor this since it was discussed earlier, but did the witness have an opportunity to see and know the things about which the witness testified? Even at trial, she admitted that she was intoxicated for the first time. She went back and forth with the police about whether or not she was intoxicated and her standard of drunkenness and whatnot, but she was so intoxicated that she still felt the effects of it at 1 p.m. the following day. The medical examiner told you that alcohol dissipates in the average person. Everybody's different. Tolerance, all sorts of things come into play. But on average, 0.015 grams per deciliter will dissipate every hour. So you can do the math. 0.015 times 14 puts her at 2.5 times the legal limit. For those reasons alone, you should not believe anything she told you. You should not believe anything she told the police. You should not believe anything she told the doctors. She was at 2.5 times the legal limit. She has a gap in her memory that's unexplained when I brought up the photograph at 11:03. You can't have it both ways. I don't remember 11:03 to 11:12, but I was upstairs in the shower hiding. Does the witness seem to have an accurate memory? Well, this ties into what we're talking about. But again, there's a glitch in the matrix, 11:03 to 11:12. Her memory is not accurate. By her own admission, I don't remember. She tells the police when they show her the video, I don't remember that happening. Was the witness honest and straightforward in answering the attorney's questions? I submit when we got off script, and by we I mean both, with both attorneys, she wasn't as honest and straightforward as when it was a very directed and smooth examination. I came out of the gate with something that was off script. Tell me about Pamela Erickson. Tell me about Christine. Tell me about Crystal. Because she's the one that said cheating to her meant pornography. Well, ladies and gentlemen, you know, she knew exactly who those people were, and that she believed that he was cheating on them with her. And apparently she is too, with some guy named Ben. That when I describe this as a violent, nonsensical relationship, that's exactly what it is. It's not to downplay the violence. She got stabbed. She had minor surgery. It got infected. Those injuries are real. But they just don't apply in this case. They just don't apply when you use that self-defense instruction when she's the aggressor, if it's to be believed.
Judge, object.
Approach.
I don't know what he's objecting to. I think this is I think Jay is in a difficult position because he, as a prosecutor, prosecutes DV cases. So he can't, in good conscience, sit there and say, oh, they lie, or it's not real, or it doesn't matter, because it does. He can't pretend it's black and white, because it isn't. But he can say what the truth is, which is it doesn't apply in this case. I'm going to see if I can fast forward.
Let me say it loud and clear. Bad spouse syndrome does not have any effect on this case. It has no relationship to this case because she is the aggressor. She zipped him shut in the suitcase. After he said, I couldn't breathe, she wouldn't let him out. Therefore, all of the instructions above that paragraph of however do not apply. They do not apply. Now, turning back to what I was saying, did the witness have some interest in how the case would be decided? Well, of course. 3 out of 4 panels that y'all came from indicated to the judge fear of punishment was more important than the fear of public speaking. It speaks for itself. She has an interest in the outcome of the case. Now let's talk about, does her testimony agree with the other evidence in the case? You do not have to accept this story. Let's pretend, as you should, because all 6 of these things, we haven't even gotten to the inconsistent statements. Let's pretend her testimony doesn't exist, and you just have to look at the circumstances. The testimony from the defendant is George Torres's head is here. You can stand if you need. You've been sitting a long time too. His head is here. His butt is kind of down here. His feet are here. And his hands and his knees are up here. He's in the fetal position, if we remember right. The hematoma on his head is on the left side. The bruises, the deep bruises on his back, are on his left side. You hear that? That's solid. You don't have to accept that she put those marks on him when he was in there. The evidence doesn't support it. You can conclude she used this bat when he was outside the suitcase. You don't have to believe her when she said they were playing hide and seek. You don't have to believe her because she doesn't know the rules. She came downstairs, saw what she had done, and had all the opportunity in the world to clean up whatever mess may have been at the bottom of the stairs. But ladies and gentlemen, physics doesn't lie. She can't expect you to believe her testimony about the loud boom being the day before compared to her 2 neighbors who weren't drinking, who have no interest in the outcome of the case, who suffer from none of the infirmities of her testimony. She suffers from all 6 infirmities. When her neighbors say there was a loud boom that night, there was a loud boom that night. Did it shake the wall they shared in common? It shook the wall that they shared in common. Did she have any injuries consistent with being dragged up and down the stairs the night before? No. You saw the pictures the CSI took. You don't have to accept her story about hide and seek. Something made that loud boom. It takes energy to make a loud boom. Energy that could very well be in the form of somebody going down some of the stairs, all the stairs, in the suitcase, out of the suitcase. But that's what the evidence supports, is there was a loud boom that shook the walls and interrupted a FaceTime conversation that was so loud that the girlfriend on the other end heard it. Something loud happened. And then there was silence, according to the witnesses. And they can argue that Juan Torres' testimony was great for them. It's great for the state. She was screaming at him already at 7:30 p.m. She was already on her bully pulpit. And we know she doesn't need to put him into the coffin to get on her bully pulpit. There's video after video of her on her bully pulpit telling him how it's going to be, how you're going to live your life. Go take a walk. Do this. Do that. You don't have to accept anything she said. It's inconsistent that he received the hematoma to his head, his bloody mouth. How is his mouth getting bloodied inside the suitcase? That's protected from her and her bat. But that suitcase, a 100-pound drunk woman is not beating through the wood of that suitcase or whatever it is that's making that noise when it's thumped. Ladies and gentlemen, those injuries happened outside of the suitcase. Ladies and gentlemen, somebody or something went down those stairs. She has no injuries consistent with going down the stairs. He does. He has blunt force trauma all over him. You don't have to buy her story, and you shouldn't. The inconsistencies, I'm not going to belabor it. Your dinner is waiting him back. Let's just briefly talk about the experts, and we'll move on to the end. Dr. Brandon was absolutely fantastic. He explained everything that you all needed to know about battered spouse syndrome. And this isn't about whether one of them or both of them had battered spouse, because at the end of the day, she's the initial aggressor, and she had the duty to do the things that the law requires. But it does call into question the credibility of the past power dynamics of their relationship. Those videos speak for themselves. The officer in the last video asks him, dude, you're a guy. Why don't you do something about this woman, your wifey, who you don't want to rat on for beating you? It's like, man, I'm not a beefcake. I'm not going to rat her out. There's countless examples, if you apply Dr. Brandon's testimony to Juan Torres, that really shows you the power dynamics of the relationship. He was her violent pet. Dr. Harper, I don't find much quarrel with what she says about battered spouse syndrome, and nobody should. I mean, she's the expert. But she's not Miss Boone's treating physician. She's not her treating psychologist. The way it was described in argument, and I believe from Dr. Brandon's testimony, was she's supposed to be a forensic detective. Get to the bottom of this. She's going to come in here at trial and tell you her opinion you should rely upon. With 9 visits, she never asked the defendant what it is the victim said that put you in imminent fear of death or great bodily harm. That's the crux of the matter, Doc. You're never going to ask her what it is he said or did for this grand jury instruction about threat of force or use of force? It's remarkable. And, she didn't review everything that was presented to you. At the end of the day, it's your opinion that matters about this relationship. And again, we agree with Dr. Werner. It doesn't matter. She had the duty to retreat. She had the duty to take the chokehold off. And if it was too dangerous for her to directly take the chokehold off, she had the duty to do something else, everything in her power, to stop him from dying, because she started it. She set it in motion. She used the force grip on him from a distance, the couch and from bed. It was her obligation to stop. She didn't. But Dr. Werner, she was called by the state of Florida after having evaluated and listened to the defendant give a similar story and concluded battered spouse doesn't apply. So she was never asked to delve any deeper into it. Given the information that she did have, the limited information, she agrees, yes, Miss Boone has battered spouse syndrome, but it doesn't apply to the case because she was the aggressor and she did not fulfill her obligations. And really just your gut common sense. Go back to jury selection. In jury selection, there was examples about bullies day after day doing something to somebody. And somebody raised their hand and said, don't they have to do something that day? Don't they have to do something that day? And he didn't. After he was put in fear of death and told her he can't breathe, the imminent threat of great bodily harm and death she is describing to you is him fighting for his life to escape. She did not fulfill her obligations. There's details that matter. Again, not to belabor it. I mean, the evidence in the body-worn camera and the 911 calls, it's not offered to prove the truth of the matter as who stated what. Who knows what happened between these two? You see them with the police. Can't believe anything they're saying. It's not offered to prove that she's a bad person. It's not offered to prove that Mr. Torres is a bad person. It's simply offered to call in question the reliability and credibility of what she said about the past. That's all that it's there for. But there are some nuggets and some Easter eggs. There was an argument made during closings that Mr. Torres knows not to do anything when being videotaped. Bizarrely, shortly thereafter, they showed a very edited clip of him attacking her and slapping the phone out of her hand. He knows he was being videotaped, and there was another video like it too. So to make the argument that he doesn't do anything, he's a good boy when he's being videotaped, it's belied by their own argument. They showed one of the videos. Learned helplessness. She seemed to control everything. I mean, his birth certificate, it gets torn up when he doesn't comply with her wishes. You'll see the rest of the text messages if you choose to delve into them. But I would suggest you don't have to, given the jury instruction about aggressor. Ladies and gentlemen, this has been a long 2 weeks, and you are making a very, very important decision for Ms. Boone, and a very, very important decision for Mr. Torres and the state of Florida and his family. He's dead. She killed him. She's admitting she killed him to have this affirmative defense if I was justified. It was not justified under our law. She does not get to decide that she has a license to kill because of her past grievances. The law requires her to stop using the force that she started applying to him. And she didn't. She didn't withdraw. She didn't tell him he was withdrawing. She didn't use every means available to try and stop this from happening. She didn't. And you know what was in her heart. She tells you it's hatred, ill will, spite, and venom. This is not a self-defense case under the law. Go back and follow the law. You cannot feel sorry for her. You cannot feel sorry for him. You cannot feel angry at her. You cannot feel angry at him. It's maddening to see their relationship. It is maddening. Nobody would want this life for yourselves or your children. It is violent nonsense, but it does not affect what she did and what her duties were under the law that night. She wanted to punish him. She did, and then she left him there. And she had an obligation, if you even believe her story about the imminent threat for him fighting for his life, she had an obligation to do something about it and not just go upstairs and let him suffocate. Thank you.
Thank you both. Members of the jury, I have some additional instructions to read to you. If you would be so kind to turn to page 21 of 22. Instruction 3.12. Verdict. You may find the defendant guilty as charged or guilty of such lesser included crime as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. If you're looking for it, you don't have it. I do. That's why we only have one. The verdict form reads, in the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida, case number 48-2020-CF-002603-0, State of Florida Plaintiff versus Sarah Boone Defendant. Verdict. We, the jury, find the defendant guilty of murder in the second degree as charged in the information. We, the jury, find the defendant guilty of the lesser included offense of manslaughter. We, the jury, find the defendant guilty of the lesser included offense of culpable negligence. We, the jury, find the defendant not guilty. So say we all, dated at Orlando, Orange County, Florida, on this blank day of blank, 2024, signed the foreperson. Final instruction, members of the jury, page 22. Instruction 3.13, submitting case to jury. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as an email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court deputy while you deliberate. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. All exhibits, with the exception of Exhibit 10, which purports to be a wooden baseball bat, will be sent into the jury room with you when you begin to deliberate. If you wish to see Exhibit 10, which purports to be a wooden baseball bat, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply in this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. The parties approach.
Okay, guys, we're going to be on verdict watch. How is everybody doing? Wasn't that great by Jay? So they are willing to work a little later than 9?
Members of our jury, I want to take a moment and thank you for your time, your service, and your participation in this very important process. As I said to you last week, be it Monday or Tuesday, maybe even on Wednesday, without your sacrifice and your service, the wheels of justice would simply come to a screeching halt. And on behalf of myself, the state, the defense, and Ms. Boone, we thank you for that sacrifice. With that, jurors wearing badge 295, 9, 569, 515, 130, 249, and 448, and 110, you've successfully served as our alternate jurors in this trial. I wish I could give you more than my thanks and a hot meal that's waiting for you, but I do thank you for your service and your sacrifice. Courtroom deputy is going to take you out at this time so you can collect your meal, and I'll meet you back there momentarily to give you your jury certificates. Thank you for your service. The rest of y'all, if I didn't call your badge, you need to hang out.
Sarah's not smiling sweetly at them as they leave this time. So let me check on you guys, see how you are. I think that
You all
people...
may be seated.
Oh.
For you 6, you are that will be deliberating in this case. I thank you again for your time and your service. The exhibits will be brought back to you momentarily, and a meal is waiting for you. We will work till approximately 10 o'clock tonight if you do not render a verdict before then. And I thank you again for your time and your service. I'm going to ask the courtroom deputy to go ahead and take you back now to the deliberation room. You can bring your phone with you. There's a basket that the deputy will take and collect for you. Thank you.
Some of you are thinking she looks really stressed.
You all can be seated. Thank you very much.
May I raise something real quickly? Did you intend for the jurors to take the notes into the deliberation rooms?
Yes.
Okay, I would object to that on the grounds that it allows one juror to potentially assert that their notes are better than others as opposed to just relying on their memories.
Any response, State?
That's not the law.
There's a verdict form, there's an instruction that I read specifically on that, sir, that no one juror's notes should trump another juror's notes or their memory. So your objections are ruled. Mr. J and or Mr. Cacciatore, do you have the clean laptop for the review by the defense? And while we're putting that together, can both the state and the defense review all exhibits that were entered into evidence and confirm they are what they purport to be, so that all exhibits that were entered, with the exception of Exhibit 10, the bat, would be sent back to our jury? Yes, please.
Oh, I so want them to just like send Owens, send him to the corner or something. Morgan's saying, I'm wondering what's going through Sarah's head. Yeah. I like that Mr. J saved a lot of the stuff to the end so that Owens couldn't come back and twist it around again.
Yes, please.
Crystal Dawn, Sarah's panicking because they have to follow the law and not just what Sarah wants. Exactly. That's why she didn't want a trial. If there's an appeal, Owens will try. Whoops.
Acted.
What?
Yes. Yes.
All right. Okay, so we'll send the exhibits back with the exception of Exhibit 10, the bat, and the clean laptop to our jury.
I think
Ms.
this
Boone, I've got a
stream
couple of questions to go over with you
ended.
again,
Hang
ma'am.
on a second.
If I could. Ma'am, you were sworn previously this morning?
My stream just jumped. And
Last week through today, you've been seated next to your lawyers at counsel's table. You've had the opportunity
so I don't know
to observe the opening statement.
if it's over or what.
The
Hang on.
the
Sorry.
opening or the you've also had the opportunity to observe all of the
Yeah. I think this feed is ending. Skycat saying let it play. I thought it ended. I'm just checking on it. Right? I'm making sure that there is something to play instead of a glitch that keeps repeating. So, just give me 1 sec.
Need to get into it unless there's a 3850 claim that there's a conflict of interest.
Is there anything other than concern or speculation that you have?
Just things in passing that have been said and observed. It's a very expensive defense. That's my concern. I don't want her to be able to raise any arguments that, well, I would have pled if I had a conflict-free lawyer who did not want it to go to trial for his or her own reasons.
Okay. Mr. Owens, is there anything of concern that I need to be aware of in camera?
No, sir.
Mr. Henderson, same question to you, sir. Is there anything of concern that I need to be aware of in camera or otherwise?
No, sir.
Mr. Beck, same question for you. Is there anything of concern that I need to be aware of, be it here or in camera?
No, Your Honor.
Okay. All right.
Judge, and if you need to inquire from my client about whether or not she wanted to enter a plea or whether she wanted to go to trial, but, you know, we made it clear that it was her decision, not my decision to go to trial because I'm trying to gain some publicity or money or book deal or whatever. That was her decision. There was some strong conversations we had about what was on the table. And Ms. Boone, as she has a right to, wanted a trial.
Mr. Henderson and Mr. Beck, would you agree with Mr. Owens' recitation as to none of the financial issues being book deals or anything on the table at this point in time?
Judge, yes, because I definitely don't know about it.
Okay.
Because
Mr. Beck, anything to add, sir?
Only, Your Honor, that I believe this is attorney-client privilege information, but there are no concerns with my comment.
I colloquied Mr. Owens, your client, before we picked a jury as to the offer in this case and whether or not she was ready and wanted to proceed to trial. And she had affirmed at that point in time that that's what she wanted to do. So I see no reason to inquire of that further. State, is there anything else we need to address?
No, Your Honor.
Defense, anything else?
No, sir.
All right, please give your cell phone numbers to Madam Clerk. We will be on verdict watch. And I thank you all for your hard work in this case. We're off the record.
Wow. Marco Barco saying plausible deniability. Yeah. So they're denying that there's any kind of a book deal or something. So I saw a lot of you really cheering for Mr. J. Somebody said, I think Sarah will be writing to Vinnie Politan soon. Good Lord, I hope not. I hope not. JSS says, please do not stop self-snitching. Yes, the prosecutor was good. So during jury deliberation, she would be held at the courthouse. And different places may have different rules about how that works out. Kimberly, deliberation starts now. They're going back to deliberate now. And Giovanna is saying they're there till 10. That is also what I understood. So we could get a verdict tonight. If not, they come back on Monday. So Brenda's saying Owens did want her to take the plea deal. Yeah. Somebody in the chat saying I'm nervous. I'm not really nervous. I think Mr. Cacciatore really laid it out. I was nervous about the jury instructions because it's so easy for people to misunderstand them. But the way Cacciatore went through them, does this apply? Yes or no? And Owens got up there and just, I don't know, it's like he was just like throwing mashed potatoes and gravy around the room. Oh, throw this out here and throw this out there. Look, squirrel. Oh, word salad. Let's toss it around. Let me appeal to your emotion. Tell you about my small town. And Jay got up and made it clear again. It was good. You can't. Good night, Christine. You're too tired. You can't say that Mr. Owens didn't try. Oh, some people think that Owens had no plan beyond getting a plea. Well, that plea deal was a pretty sweet. That was a good offer. Yeah, Christine, my brains feel like mashed potatoes right now. That's probably why I thought about mashed potatoes and gravy. Plus, I'm really hungry. I think it's going to take them a couple of hours to go through the information. Well, maybe they won't go through it all though. Who knows? Oh, Carrie's saying eat dinner and gossip, then take a soft vote, then deliberate. Interesting. Clint is saying, I didn't watch any Owens. I muted you all. Just, just real honest, Clint. Just, yeah, I'm not handling this. Forget it. Oh, Mace is saying, yeah, the most memorable portion is when Mr. J hit the suitcase, kicked the suitcase, how hard that suitcase was. And I've been frustrated for the whole trial thinking it wasn't hide and seek. It wasn't, he couldn't have got those injuries the way she says. Ah. And at the very end, that's when he brings it all up. Dirk is asking me my best guess. What's the outcome? Honestly, my guess is is not any more informed or better than yours. So, I mean, if I was there, I would vote guilty. I don't know. What about you guys? What do you think? Curtis saying 4 years I didn't know about the bat. Yeah, because she lied. This just came up recently. I guess she had to explain some injuries on him. So, I mean, the whole time, and nobody laid a hand on anybody. I fell asleep. Good day. All that. And so she had to explain some injuries. And then her story changed. She spoke to the last doctor, Werner. And 22, and at that point, there was no overt act. It wasn't till 22 days later, that is at the trial, when she decided that there was suddenly a threat. So I really liked that Mr. J said, hey, you don't have to believe any of this. You don't have to believe hide and seek. And if the jury hasn't heard about the case or doesn't know a lot, they haven't been getting hide and seek drilled into their brains for 4 years. Thank you, Morgan. Morgan says, I hope the jury is swift in giving justice. Yeah. Angel Baby thinks guilty. Marco, guilty, murder 2. Rosie, guilty, second degree. Verdict back tonight. Detective says, I hope guilty. Verdict will come fast. Guilty in the second. Yeah, Paige is pointing out, even as little as 2 months ago, a lot of people thought this day was not going to come. Last year, I created a series of little videos because I was going to do a countdown to the Sarah Boone trial, but then the trial got moved again, delayed. And this year I thought about pulling that out, and I decided not to because I'm just going to get delayed. So I just deleted them. Yeah, I can't imagine what Mr. Torres' family went through. She told Dr. Harper about the bat. Oh, she never told Dr. Harper about the bat. That's correct. She told Dr. Werner. I think if I'm incorrect, somebody can correct me, and I'll accept the correction. Vicinator says, I'm not nervous. This case is so clear. In my brain, I think it's really obvious. I think it is clear. Yes, his mother especially. Yeah. Four of Cats is saying, I really think he did that, meaning Jay holding everything back, because he knew Owens would just throw mud in the water. I agree. I think so. I think it was a good strategy, too. Owens was a hot mess. Somebody else saying, yeah, guilty, second degree. Kimberly, guilty, second degree sentence maximum. Is that what you're hoping for, or is that what you think is actually going to happen? JS says Sarah looked panicked and points out she can't control this anymore. Yeah, it's going to be hard for her. But, it was really hard for Mr. Torres. So, you won't, what I'm going to do for the verdict watch is I'm leaving the stream open. I, so you won't get like a notification. I'll leave the stream open. I'll leave the chat open. I'll pop Scully saying, thank you for talking over Owens. Oh, thanks for letting me. That was, oh, he was so hard to listen to. Anyway, so I'll pop in and check in and see how everybody's doing, maybe chat with you. And we'll just be on verdict watch. But I do need to eat something, and Watson needs, so I need to take a little bit of time to do some self-care myself. But I'll leave everything up and be checking in. Mace is asking, do you think Sarah chose George because he was small? Um, I don't know that so much. I think they do choose people who they can control. I think they choose people. I mean, in her case, she wanted somebody basically to look after her. So, first, she would have to find a man willing to look after her and try and work her magic. And yeah, with somebody like that, if she can't control them, the relationship isn't going to last very long, right? Sky Cat, George was vulnerable. I think that's why she targeted him. Yeah, they know. They know to target certain people, and they might even try out this one over here, and it doesn't work out for them. So they, you know, swing over here and see if that one works out. What can I get over here? They do that. WD-40 thinks murder too. Unhyph- Unhyphenated saying the hitting the suitcase left me thinking, rather than sending George and the suitcase down the stairs, could it have been just George? That's possible. That is a possibility. And we're never going to know. But there was no hide and seek. Somebody's saying we missed Sarah's answer about her lawyers. I'm not sure what you're saying. Clint is saying not worried, sure it's going to be murder too. I think these jury instructions were pretty clear. And the verdict form sounds pretty clear too. Okay, I'm going to leave everything up I'm going to go get myself some dinner and I'll come back in a while. You're welcome to stay and chat. You're welcome to come and go, whatever you would like. So I'll come and check on you in a bit. If I'm going to tell you to do self care, then I should probably listen to myself. Thanks, guys. I'll see you in a bit. How's everybody doing? We're still waiting. Okay, love, yeah, I think Sarah is in a holding room by herself. You can't see me? My cat likes true crime. I'm down here in the corner. DM, thank you as well for the last couple of weeks. Thank all of you. I think some of you have made some new friends here, which is nice. Live, laugh, love. Hi. You've been lurking all day. It's nice of you to pop up and say hi. Devon is saying, thanks for staying open for the verdict. Yeah, we can't go through all of this and not watch the verdict together. Goodness. Holly's mom says, I took a break from Owens. He triggered me a lot. Yeah, yeah, I get it. And good for you for knowing when to take a break. So Tracy's asking, where is everyone coming from this evening? She's in Northeast Arizona. My cat likes true crime is in California. It's 5 p.m. in California. DM is asking, do you think they'll reach a verdict tonight? Lord, I hope so. Chicago. Nikki is asking, do people chat in the community or do I sorry, I missed the end of your comment, the or. So after this, people can chat in whatever comment section they want. A lot of people prefer certain cases and not others. And so people just talk in the comments. But I think this has been good for people to chat live. And I really do like having the two-way conversation with you rather than trying to do a video into a camera. So I might do more of these in the future. Someone from Michigan, Maine, Central Georgia. Toronto. Ian, you're in my neck of the woods. South Australia. Another one from Maine. I don't know if anybody's old enough to remember that show. There was a show called Romper Room, and the lady would hold up a mirror and say people's names. I see Lisa, and I see Nikki, and I see Bobby. Do you remember that? Someone from Florida, Northern England, Michigan, New York, UK, Santa Cruz, Fort Worth. Yes, you remember Romper Room. Harrison says, yeah, that was creepy. I remember one time the lady said, Lori, and my mother said, see, she sees you. And even though I was young, I just said, no, she doesn't. She's in the TV. She doesn't see me. I knew even then. Netherlands. I did not see Mr. Torres's family interview. Haven't. I've been on here all day. I will watch it at some point, though. Cram says, I've watched almost every day. The defense did better than expected. Oh, CJ says the chat has meant a lot over the last week and a half. That's good. New South Wales? New South Wales, that's in Australia, yeah? I know there's a New South Wales there. Somebody says, romper room, we're going way back. Yeah. Yeah. The kids talk about music and they talk about oldies, and I'm thinking, what? I mean, yeah, just, it's really new stuff to me. I remember 38s. Jay Z says that, yeah, the defense had me worried for a little while. South Africa? It's 2 a.m. in South Africa. Wow, Sandy. Paige says, yeah, a lot of trials you just listen to, but this one, the live chat, was much needed. Yeah, there were a lot of issues, a lot of nuance to talk about, a lot of triggers, right? I think a lot of people have had experience with, well, I know, with DV, with narcissists, with people being cruel, with people lying. I think it was a good case to cover because there's a lot to learn. Lisa's saying 1 hour down. Yep. Oh, so somebody from Belgium as well. It's 5:11 in Washington State. My cat likes true crime. Yes, it's good that Sarah had a defense. Yes. Hiya, Angel Baby. Irene May says, will Owens have to pay the other lawyers and his expert witness? JAC is covering the expert witness, but the other lawyers, I don't know if they're doing them a favor or what, but they did hire a trial consultant. I don't know what the deals are for all of that. Michelle is saying, I feel so old. Yeah. Oh, I didn't even think of putting up a verdict clock. Christy's from Washington State as well. DM is asking, am I going to cover a new trial next? So right now, there are a few things on the burner, so I'm anticipating Karen Reed. I don't know. I don't know whether to cover it live. I might. I don't know. Definitely Corey Richards. Definitely. So those for sure. I have a list. So yeah, I think I'm going to need to take a little bit of time off though, because I haven't been doing anything and I have responsibilities that I really need to attend to. Ada's asking, what was the discussion in court about book deals? The prosecution filed paperwork saying he wanted an in-camera discussion with the judge about potential book deals or whatever the financial arrangement is with the defense team, between the defense team and Sarah, because it just seems so strange that they're spending such a huge amount of money and resource. And it's odd that they would spend all that out of their own pocket. Thank you, Crystal. And, you know, there are rumors circulating about book deals and Netflix and all this. And if that's the case, there's a possibility that there is a conflict of interest between Sarah and her own defense team. And Mr. J wanted to make sure that there is no conflict of interest. This protects Sarah as well, actually, but it also protects the process. We don't want to find out later that there was some big conflict of interest and Sarah gets a whole new trial. We don't want that. Thank you, Holly's mom. Pam Hupp? I thought she was done. She's not done? Is she that writer who unalived her husband and wrote a book about it or something? No. She unalived her husband and it was the same as the book she'd written previously. Is that right? Okay, well, if she pops up, I'll do her because she's bizarre. Kurt's pointing out you have to imagine how hard of a job it would have been to represent Sarah Boone here. Oh, yeah, definitely. Poetic Justice says there's something about Pam. Yeah, there's something really off about her, huh? Corey Richens, yeah, I'm going to cover that one. Miranda is saying, I love that they're trying to cut off shenanigans Sarah comes up with. Thank you, Nikki. Okay, Blade is saying, cover Pam Hupp. If, you know what, I'll write it down. If it's still happening, I'll cover it. But for some reason, I thought that was done. I thought I caught some clip of her testifying or something. Oh, okay. So maybe I'm mixing Pam Hupp up with somebody else. Marco, are you asking me if I watched Robert Tellis, or are you just asking just everybody? Yes, Corey Richens would be a good one to follow and talk about. She is diabolical, and so is her mother, in my opinion. I have to add that for legal reasons, in my opinion. Oh, you were asking me. So no, I didn't watch the trial. I have I have responsibilities. I can't watch them all. I did, however, catch bits of his narrative testimony, and I thought my eyes were going to fall out of my head because I was rolling him so hard. He was just so obvious. It was ridiculous. Lily is asking if I covered the ballerina murder case, Ashley Benefield. I didn't cover it. I did watch or listen to some of that one. Pam Hupman killed her best friend and collected the insurance money instead of giving it to the widowed husband. Oh. Oh, she pled no contest. Okay, so it's over. Verdict watch started. What do you guys think? Maybe an hour ago? I noticed though, when I look through my playlist, I seem to be covering a lot of women who have committed crimes. And it makes me wonder about my own psychology. Why am I following those ones? Squid saying Verdict Watch started about an hour ago. And then she killed a mentally challenged man? Oh my gosh. Steven, when did I start watching true crime? I never watched true crime. I worked in the criminal justice system, so I hated watching true crime. I started about the time I started my YouTube channel, actually. I was watching Letitia Stauch. I just flicked it on for something to do. And I got so irritated by the misunderstandings that were being circulated that I got on and made a video and kind of ranted. And then people started following me, and I was like, oh, okay, I guess I'll cover true crime. Chrissy says, I don't think Sarah could have done a narrative testimony because she couldn't keep things straight. Yeah. What does it mean to do threat assessment for a living? So, there are a number of areas that you could do that in. You could do that in the military. You can do it for big corporations. You can do it for courts. You can do it for police. It covers a wide range of things. So, if you're a threat assessment specialist, you could work in, well, like I did executive protection for a while. So you are assessing for, say, assassination attempts, bomb threats. You can work in the area of like preventing workplace violence. I dealt with a lot in the courts. So domestic violence, stalking cases, all kinds, anything involving a human being and their potential to pose a threat either to a specific person, a specific entity like a corporation, or even the general public. I hope that answers your question. Oh, it was Nancy Brophy who unalived her husband, right? Yeah, it's easy to get them mixed up. And I don't have time to watch all this stuff. I owe my publisher 2 books. I was supposed to be finished one of them this summer, and I've been making YouTube videos. And in between making YouTube videos, I've been trying to catch up on other responsibilities. So, and Christmas is coming, and so I am going to have to take some time to try to at least make an effort to get caught up on some stuff. Rosalina, I think if Sarah's case had been delayed again, she would have changed her story. Yeah, possibly. One of the concerns about with cases getting delayed is witnesses forget things, or they move away, or they pass away. So when Mr. Marino was on the stand, he's being asked to talk about something that happened a long time ago, right? And he's lived his life in between that time. There was a TV series about Pam Hutman. Oh, the detective saying that he liked the way I narrated the interrogation video and pointing out the cycle of abuse. Thank you. I got a lot of flack for that. A lot of people were really ticked at me. I was too hard on her and I'm mean. And then on the flip side, I was too easy on her. Paige, I don't have 2 more books. I'm supposed to write them. I have a contract and I'm supposed to do it. And, by the time I'm done like this stuff and look after Watson, my brains are mashed potatoes. Darlene, I became a subscriber because of this case. Well, I hope you stick around, Darlene. Yeah, the Soto case would be a tough one. Sandy, are you getting eaten by mosquitoes? Nikki's saying you had a case, a televised case in Scotland 40 years ago after the fact. Wow. Do they televise all cases in Scotland or just some of them? How does that work? Tracy, I started watching it when the letters started. Yeah, those letters made me crazy. Hi, Leslie. No news. It's verdict watch. We're just waiting. Squid says, I found you through the Letitia Stout trial and your ranting was cathartic. Yeah, I get it. And when I'm talking to you, when I'm live and I'm yelling at Owens or whatever, and I'm seeing you guys react in the same way, I get the same benefit from you. Yeah, Stout was clearly faking a mental illness. And that Dr. Lewis, oh my, oh. Detective says in Australia no cameras are allowed. Same with here in Canada. Otherwise, I would cover more Canadian cases because some of them are pretty interesting. No televi- no televised cases in Belgium either. Oh, Kurt's saying you aren't even allowed to interview inmates in Australia. Interesting. What's in? Eat your stick, pups. Where's your stick? I gave you a stick. Where'd it go? Holly's mom, his outburst against the victim's family finally broke me. Yeah. Viv says Letitia was a terrible faker. She was ridiculous. Rosaline is asking, was Lewis the one with the son that filmed the interviews? Yeah. And he was caught like smoking weed somewhere around the courthouse in the hallway or something, stairwell. The whole thing, yeah. It was bizarre. So Mr. J is prosecuting Soto. For a small office, they have some pretty heavy cases. Oh, Kurt was asked to interview a specific offender and was denied. Jay Z says, yeah, Dr. Lewis's son was caught in the court hallway. Oh no, Holly heard me say stick and now she's looking around. That's funny. Andy, your cat likes to watch the videos of Watson? That's interesting. Marvin saying yesterday was a long day with all the video footage. Yes, it was. And it wasn't just that, it was the video footage. It was just so heartbreaking. BJM, time ticking. At least we know Sarah must be on edge. Yep. And she doesn't like it. Her big thing is what's going to happen, what's going to happen. Because she wants to control what's going to happen. And now she cannot. She will not be liking this. She, oh, sorry, Piber. I don't know how to pronounce your name. I'm sorry. So I caught that flyby. Thank you, but I missed the comment. So Sarah, you know, if her lawyers are with her or when her lawyers are with her, she's going to drive them crazy. Yeah, CZM Fox says that I thought the videos were very telling. Yeah, they were. I hadn't seen that or heard of that before. Juno says Sarah was not smiling after rebuttal. Yeah. Rhiannon, no more Pop Tarts for Sarah now that the trial is over. She can get Pop Tarts in jail. She couldn't have Pop Tarts during the trial. I saw Sarah trying to smile at the jury at the end, and it didn't look good because it was obviously, she was obviously struggling to keep on the mask, right? Hi, San Francisco. Well, thank you. Thank you for your comments. Thanks for being with us. Yeah, Owen did make it unbearable. Marco says last time Owens answers a handwritten ad from an inmate. Blade thinks, I doubt she thought they would deliberate today. Gwen, Pop Tarts. You don't know what Pop Tarts are? They're like these pastries, sort of, that you put in the toaster. I wouldn't even call them pastries. They're called pastries, but if you're European, you wouldn't call that pastry. Somebody saying overall George didn't come across as a bully. I didn't think so either. Especially when they were having that conversation and he's telling her, let me know where you are when you go out. Let me know when you'll be back. And she's saying, oh, what? I can't have friends? She just took it and interpreted it on purpose in the worst possible way. And I think that was an intentional misinterpretation so that she could fight with him and put him down. And even then he said, no, 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 you can have your friends. Basically saying, look, I just want to know, because if you don't come home when you're supposed to, I know to come looking for you. I know maybe you're hurt somewhere, right? Miranda, it seemed like she would push George until he cracked. Yeah. Sad he thought he deserved to stay with her. Yeah. 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 Somebody's saying he seemed like a funny, nice guy. That did come out, right? It was him trying to lighten the mood. It was her having the tension build up. No malicious, Stephen says. Andy said, Sarah is non Papas Tardis. That's funny. It reminds me of the, the Wile E. Coyote cartoons. I'm just picturing Owens, off of a legal cliff, and you know how Wile E. Coyote looks at the camera like and stops in midair, like, oh boy, uh oh, that's Owens. Leslie, nothing's happening. Oh, hang on. Let me switch screens. Let me check. I don't see anything happening. Oh, maybe there is. Hang on. I don't know. We're gonna see. Could be a question. So some of you are saying you're hearing there's a verdict. You're hearing that from a YouTuber. How's he know? Okay, if they're coming back in court, we'll see. It could be simply a question. We'll see. If it's a verdict, that's awfully fast. Gosh, I'm glad I didn't fart around like at dinner time. Glad I came back. Oh, something's going on. You guys ready? Oh, Fox 35 is saying it. Okay. I trust them more than a YouTuber I don't know. Oh my gosh. I am so glad you're here to see this. I'm so glad we're all together. Moon Goddess says I'm shaky. Yeah. Finally, finally. I can't see them coming to a not guilty verdict or a lesser charge this quickly. I would think that would require more discussion. But what do I know, right? I want the camera to be on her face, but the way the camera's angled in this courtroom, it's hard to see. So I might have to move my picture up. Yeah, an hour is like enough time to eat dinner. Kurt's asking, will sentencing take place another day? I would imagine so. But people are telling me sometimes they don't wait, but I would imagine so. A lot of people with butterflies here. I got my fingers crossed too. Oh, prosecutors are there. The jurors, well, no, it's too early for them to be saying we want to go home. So it's not that. Carrie says Mr. J made it so simple. If they followed his logic, they would have to convict second degree. Yeah, someone else is saying it's no way it's not guilty this quick. I tend to agree with that. Paige is saying it's this is going to be a surprise for Sarah. She's probably not expecting anything this quick. Someone asked, would everybody be coming back in for a question? Yes, they would. All the lawyers and the accused would have to come in for that. Rebecca's saying, however this turns out, George was finally heard. At least somewhat, yeah. Yeah. I believe George. A. Stevens says, Sarah's going to blame Owens. Of course. Of course. She's going to blame anybody but herself. Everybody but herself. She would blame the Lord Jesus himself if she could get away with it. I saw in the chat earlier, one of you said, "Oh, nobody start praying because Sarah might burst into flames." That was so funny, but it was a bad moment to interrupt and point it out in the chat. But that was funny. I don't know if Sarah will have an outburst or if she'll just do her angry face. Or she might go, "Oh, poor me." Buffy is asking, is this good, guys? We think it is. A lot of us think it is. But that's just opinion. Yeah, I think the state did a great job in closing as well. It was good. AKA the cat lady, well, we know she doesn't cry. She does cry for herself. We've never seen her cry for anyone else. And through all those letters and protestations, never once did she seem sad about her not being with her son. You would think that would be the big thing, but she was mad about not getting money for I can't remember what it was, something, and Brian didn't order a book for her. I mean that was her thing. Acquired taste said my legs just went weak. Holly's mom just said Sarah's gonna send letters to her exorcist. That's funny. Goddess says, verdict? Tell me and we'll both know. You guys are hysterical. Diana, I was non compos mentis. Lisa, she uses her son for how it benefits her. Yeah, he's just a tool. We heard that on the 911 call. I have an 8-year-old I have to take care of. No, you don't. I think I saw someone saying they're getting the victim's family to come in. If that's the case, it's not a question. If they're bringing in the victim's family, it's a verdict. Wow. Lisa's telling everybody, okay, you can't pass out until after. It appears that there is a verdict. All indications are that there is a verdict. And so we are all sitting here waiting for it. Don't know what happened to her dogs, Kimberly. This is quick. This is quick. Rosie's asking me what my gut is telling me. Not anything. My brain is saying there are a number of indications that strongly suggest that there is a verdict, but I have not independently confirmed that. But I'm at this point fairly confident that that's what's happening. Bored out of my mind asked, did I get to eat something? Yes, I had scrambled eggs. And Watson had some too. Nikki's in bed watching, but her adrenaline's through the roof. Yeah, I get it. I get that. CJ says Sarah will be self-righteous. Oh, yeah. Yeah. But so many of them are led away, just still insistent that it was not fair and you guys didn't understand and my lawyer sold me down the river, that sort of thing. Terry is asking if she gets to keep her outfits. She can't wear them in jail. Not going to fit her by the time she gets out. Oh, somebody's saying, what if we're saying it's guilty because that's what we want to believe? And then it's not. And that's always a good question to ask, especially if you're feeling invested in a certain outcome. That's always a good question to ask. I think if there's a verdict now, it's likely guilty of something. I don't know. I'm going to have to rethink how I judge juries if they come back with a not guilty. Loba's saying it's in the middle of the night there and she wants to go to sleep happy. Lisa, nobody buys the hide and seek. Yes. State did a good job, yeah. Yeah, to get to a not guilty, they would have had to have had a lot of discussion, and I don't think there was enough time for it. And the way Cacciatore and Jay set it out, oh, here we go.
Second. We are on the record in case number 2020 CF 2603, State of Florida versus Sarah Boone. State, let me get your appearance for the record.
Steve Kestro on behalf of the state.
William J. for the state.
Defense.
James Owens for Ms. Boone.
Kevin Beck for Sarah Boone.
Mr. Henderson's not going to be here for the vote.
Okay, all right. Ms. Boone is seated at counsel's table, wearing the same clothing from this morning. Yes, Mr. Beck.
Judge, they've got her in chains and they've got her in the ankle handcuffs, so she can't go anywhere. I'm just asking, we would like to rise during the jury coming in. I'm asking if there's any way we can take off the handcuffs and the waist chain so that the jury wouldn't see it in case there's something wrong with the verdict form or, there's an issue, which sometimes happens, but that's my position.
Okay. I've been advised by the sheriff that during the reading of the verdict, due to Miss Boone's status as an inmate, their leg irons and the cuffs are to be attached.
Well, she's going to stay seated.
That's fine.
Mr. Beck's going to stay seated.
I would ask for us all to remain seated, and could you remind everybody in the gallery that there should be no emotional reactions to the
I was
verdict?
just about to address that, sir. Thank you very much. All right, members of the jury, my understanding, or members of the gallery, good evening. My understanding is that the jury in this matter has reached a verdict. I don't know what it's going to be until it's read. If you are unable to contain yourself emotionally and you're going to react in any way, be it in joy or in sadness, I'm going to ask you politely to excuse yourself at this time. There cannot be any emotional outbursts when the verdict is read. Does everybody understand that? I see everybody nodding their heads. Okay. State, are we ready to bring in our jury?
Yes, Your Honor.
Defense, are we ready to bring in our jury?
Yes, Judge.
All right, let's go ahead and bring in our jury. Everyone will remain seated.
Jury enter.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes, sir.
All right, members of the jury, you may be seated. Thank you. Members of our jury, good evening. I understand that you've come to a verdict in this case.
Yes.
If you could please hand the verdict form to the deputy, please. Thank you, sir. Madam Clerk, if you could please publish the verdict.
In the Circuit Court of the Ninth Judicial Circuit in Orange County, Florida, case number 2020 CF 2603, the state of Florida versus Sarah Boone. Verdict. We, the jury, find the defendant guilty of murder in the second degree as charged in the information. So say we all, dated at Orlando, Orange County, Florida, on this 25th day of October 2024. The form has been signed by the foreperson.
Madam Clerk, please poll our jury.
Juror in seat number 1, is this your true and correct verdict?
Yes, it is.
Juror in seat number 2, is this your true and correct verdict?
Yes, it is.
Juror in seat number 3, is this your true
Yes,
and
it
correct
is.
verdict? Juror in seat number 4, is this your true and correct verdict?
Yes.
Juror in seat number 5, is this your true and correct verdict?
Yes.
Juror in seat number 6, is this your true and correct verdict?
Yes, ma'am.
Members of our jury, again, I want to thank you for your time, your sacrifice, and your attention in this matter. I know that we spent almost 2 weeks together, and it was not taken lightly, and I really appreciate the time and the effort and the sacrifice that you put into this case. I want to advise you now of your final instruction. Members, ladies and gentlemen, I wish to thank you for your time and your consideration in this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak to anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. With that, members of the jury, again, I thank you for your service. I'm going to ask you return to the deliberation room. I'll be back there shortly with your jury certificates, and thank you.
Go ahead.
Ms. Boone, the jury has spoken in this matter and has found you guilty of murder in the second degree. The court adjudicates you guilty of murder in the second degree. As this is your first felony conviction, you are entitled to a pre-sentencing investigation by the Department of Corrections. Mr. Owens, are you seeking that in this case?
Yes.
Okay. State, I will order the Department of Corrections to prepare the pre-sentencing investigation. State, for the purposes of sentencing, do you anticipate eliciting any testimony from, be it the victim's family?
2 or 3 victim impact statements, sir.
Okay. Mr. Owens, do you plan on presenting any evidence during the course of the sentencing hearing, sir?
Probably some testimony from Dr. Harper.
Okay. All right. How long do you think, State, that you would need?
You mean timing-wise, or are we thinking?
A quantum of time, sir. Yeah, well, normally it takes about 30 days or so. I'm confirming with Anita as to availability. I just want to know from your side of the ledger, how much time? Okay, 15 minutes. How much time do you think you're going to need to produce anything from your side of the ledger, sir? Mr. Owens.
I'd say 30 minutes.
Okay.
30 to 45.
So if we set this for an hour, that would be sufficient.
Parties agree.
Okay.
State agrees.
Is that sufficient, Mr. Owens?
Yes.
Okay, all right, give me a moment. Ms. Barrios is checking. Just give us a moment. We can set this matter for 1:30 in the afternoon for sentencing on December 2. State, is that acceptable? It's a Monday.
I have a status hearing, but I'll make it work.
I can move it to later if necessary.
I'm co-counsel on it. I can make it work.
Okay. Defense.
Give me 1 minute.
Yes, sir.
That's Monday, December 2 at 1:30.
Yes, sir.
I can be here.
Ma'am, you've been adjudicated guilty. I now remand you into the custody of the Orange County Jail pending sentencing on December 2 at 1:30. State, anything else we need to address?
Not from the state.
Defense. All right. Thank you very much. We're off the record.
I want to watch them take her away. I've been waiting to say this. Sarah Boone, you are officially a murderer. You can't complain. Don't call me a murderer. You're a murderer. Let's watch her. Bye-bye, Fluffy. You can't say Owens didn't try. They really did put on a vigorous defense for her. They really did fight for her. I hope that Mr. J and Mr. Cacciatore go out and have like their favorite dinner. Yeah. Show Kitties is saying Owens isn't going to answer any of your calls anymore. Sandy says it was a good day. Yeah. Finally, for his family. Just, I want to watch her walk away and I want to watch the doors close behind her. I hope they keep the cameras rolling. She didn't take her papers with her. She doesn't need her papers anymore. You're done. And you know what? Someone said, I think it was Cat Lady, said she doesn't cry. She didn't cry. Yeah, Brian doesn't have to keep paying alimony. Yeah, was Chelsea there for the verdict? Did you see? So on December 2nd at 1:30, I'm going to cover this sentencing live if they're streaming it. And I expect they will because this is a high profile case. So I hope to see you back for that. Oh, they're fingerprinting her again. Look at that. No more hair and makeup. Yep. Everybody's going home except for Sarah. I think it was Tracy asking, can all of her bad behavior come in now? There are rules around that too. But there will be a lot that comes out in pre-sentence, and the victims get to make a victim impact statement. Wow. So somebody asked, is she just going to be in jail until sentencing or is she going to prison? No, she's going to be in jail until sentencing, if I understand that correctly. And eventually she'll go to prison. Yeah, no more special outfits. Somebody says she doesn't seem phased. I think she was. Thank you, Aaron. I think she was phased. I think it took her a minute to, sort of compose herself. I saw her right shoulder kind of go down a little bit. Let me switch screens here. Gravyfish says she's in shock. Somebody said the jury had Sarah Boone for dessert. It was a good day. Yeah, I wonder what her fellow inmates are going to think of all this. Rosie says, I think she knew after rebuttal that she was cooked. I was really surprised that this verdict came back so quickly. So for those just joining us, Sarah Boone was found guilty of second-degree murder as charged. Her her sentencing hearing will be December 2nd at 1:30 p.m. That's a Monday, and we will cover that live. This was a difficult, long journey. Christine is asking, should we worry about appeal? I wouldn't actually worry. Could she find a reason to sort of apply and try and, or sorry, file and try and make an argument? Sure, anybody can do that. Will an appeal be granted? That's another story. I think Kranick was very methodical, and even the defense team knew to have Kranick ask on the record, are you happy with your defense? Are you happy with your defense? Did they tell you this? They know what she's about. Goldilocks is saying, can't wait to hear from some of the jurors if they choose to give interviews. Yeah, that'll be interesting. Barely Legal Brief says, those the lifer prints. Yeah, she got fingerprinted again on her way out. Judge Kranick did an excellent job. Really impressed. I'm really impressed with him. CJ and PA is saying it's unlikely the appellate court will overturn a jury verdict. Yeah. Unless there was some huge, there would have to be some huge error or some huge conflict or something. But that judge, man, he worked hard to make sure there wasn't going to be. And even the prosecution was really generous, at least while Sarah was pro se. So I don't think I think she's gone. She's going. I'm just interested in hearing what the sentence will be and what it is that this judge will have to say in his remarks. CJ is saying they're tired and I bet they'll choose not to do interviews. I'm not sure if you're referring to the lawyers or the jurors. Oh, Blade, is it your birthday? Happy birthday. Blade says, now we see why Mr. J was so nice. He's a wolf in a sheep's attire. I don't think that Mr. J is the wolf. I think Mr. J is the sheepdog. Gwen saying, yeah, thank you, everyone. What a journey we shared. Yeah. Yeah. Jay's asking, does Sarah get to make a speech? She will be given an opportunity, unless Florida's laws are different, she will be given an opportunity to address the court if she chooses. I hadn't thought about that, but yeah, that's an interesting point. Wonder if she'll choose to say anything or just keep her mouth shut. Blade says he's a wolf to Sarah. Sarah's the wolf. He's the sheepdog, keeping the wolf away. If Sarah got out, she would be a wolf who looks like a nice little sheep going among the sheep to eat them. Gypsy says Sarah exited the scene sans a smirk. Yes. Thank you, Jessica, for being here for the coverage. It would be no good without you guys. Really, there'd be no point in doing any of this without you. A Silver says she'll have enough time to come up with a new story by December 2nd. Oh, yeah. Oh, yeah. They're going to explain to her. Owens is going to explain to her, oh, we're going to do this pre sentence investigation. And so she will do the whole woe is me thing. Life is everything's unfair. Blah, blah, blah. To whoever's conducting the assessments. Oh, yeah. But those people who conduct those assessments, this isn't their first rodeo. Oh, Kat and KD says Mr. J is Superman. And that makes me grin. That lets me know you saw my video way back. The video is titled Sarah Boone Wants Superman, because she'd written a letter and referred to herself as Lois Lane and how she wants a Superman. And so I did a whole thing on this. And at the end of the video, I said, what if? What if Superman is the prosecutor? Thank you, Jadzia. Jadzia? Sammy Bam is asking, does a jury have to deliberate for a certain amount of time? No. No, they didn't need, no. They had to, once they have considered everything and come to the conclusion that she's guilty beyond a reasonable doubt, then that's it. Lisa saying, dear Sarah Boone jury, we love you. CJ is saying, yeah, Sarah Boone definitely wanted the attention. Yeah. Yep. Ada saying, can we watch it again? Really? This Brenda is saying that it was great to be here to watch this from. And really, that is due to the people in chat. You guys have been just terrific to each other. It's really great to see. Matcha is asking, is there a law that says how long the judge sentences her for? So there are guidelines and there are the ways that they calculate it. So the minimum is 22 and a half years. So he must give her at least that much, and then he has some discretion, but then he looks at aggravating and mitigating factors. He considers victim impact statements. He considers her behavior, the information from the pre-sentencing investigation. They consider her record as well. Vicinator, she thinks she's smarter than everyone else. She's plotting right now. Yeah. She can just scream into the void. She can whine all she wants now. They're interviewing Owens right now. Really? Does anyone really want to hear Owens anymore? I'm so sick of that guy. Lunar Magic Tea Time says, now I need a new hyperfocus. Moth's mummy, her new girlfriend won't wait for her. Correct. Oh, Wyatt is pointing out remorse. So yeah, the judge will consider whether or not she had any remorse. And she does not. She has nothing. No insight, nothing. She accused the judge of being on the take, but it was a different judge. It wasn't this judge. And you know what? Judges are used to that stuff, and so are lawyers. They get accused of crap all the time, and people talk crap about them all the time. It's not like nobody actually gets their feelings hurt. Sometimes you go out for a drink with even with opposing counsel and you laugh about it. Oh yeah, would you get called today? It's not nobody takes that stuff personal. Yep, never a tear from her. Jadzia is Owens is getting the last dregs of his 5 minutes of fame. Yep. So Owens is already out and doing an interview. Wow. Yeah. Sarah must feel pretty alone right now, but not as alone as Mr. Torres must have felt. Captain Katie is saying it was Wooten. She accused Wooten of being on the take. Yeah. Oh, for gosh sakes. KPM says Owens said it was just a drunken mistake. Wow. You know what? None of us have to listen to her lies anymore. And what's coming out of Owen's mouth is just a repetition of her lies. We don't have to listen to it anymore. We know it's lies. And, I mean, if we didn't already know it, after seeing those videos that she herself took of Mr. Torres and hearing the changes in her lies, I mean, how could you not see it? Thank you, somebody help, for your comments. Jay Roberts, Sarah's alone because she kills everyone around her. They don't want anything to do with her. She did it to herself. Yeah. Yeah, she does. Greg is saying Sarah alone turned the key to her cell door by her own words and actions. Yes, she did. Yep. So now we don't have to say she's potentially guilty. We know she is a murderer. Yeah. Um, CGC Vinyl says her own cell phone evidence sealed her own fate. Ronald Reagan uh, says, I'll miss her. Yeah. I think people were entertained by some of her antics. Oh, and as Owens is saying, we did the best we could in the time we had. Dude, you had bad facts. No matter how you cut that apart and sewed it back together again, they were bad facts. And you had a liar for a client. So I don't know how you I don't know how you win with that. Yeah, Owens complaining he doesn't have enough time. You know what? Owens knew that. He took the case knowing how much time he would have. He knew that. The Heart Machine is asking how long was deliberation. I think it was what, an hour and a half? And they were back. Dr. Tracy, she lied to Owens. Oh, I'm sure she did. I'm sure she lied to everybody. She lies to herself. Yeah, Wyatt saying an hour and a half, and they ate supper in that time too. Yep. I'm glad that it was over today and that people weren't having to stress over it over the weekend. Delane saying, the first time I heard this case, I looked at my husband and asked if he wanted to play hide and seek. Goodness. Mark your calendars, December 2nd. Yep. Yep. Okay, guys. I think I'm going to sign off. Thank you so much for being with me through all this. Thank you for being there for each other. I really appreciate you. You guys restore my faith and remind me that there is so much good out there. And it was fun today getting to know some people in the chat, learning what you did for a living. It's nice to have this two-way conversation. So, good night to you all. Have a wonderful weekend. Trust your gut. I'll see you in the comments.